22. In this case, I mean, led by Mr. Kane Chaudhary, he is suffering from throat infection. Can it be adjourned for the day?
Every time everybody seeks for time for these matters.
No, Lordship, there was never such.
No,
time.
earlier also on various occasions the matters have been adjourned.
No, Your Lordship,
Yes.
the last occasion, the order
No,
passed.
no, no,
Order
no.
passed.
Ask
Lordship,
Mr. Espora, who appeared.
no,
He has
SC
mentioned
is
this
there.
aspect.
Item number 20, 21, and 22.
That's it. Oh, no, no.
Is not.
Item number 20, 21, 20. Yes, what is this matter about?
This is regarding we are challenging the provisions of the sections of Benami Act, whether it will have a retrospective effect or not. And in the recent Supreme Court judgment,
Are you challenging the provisions of an act? Then why is it come before a single bench?
whether the act, we are challenging a show-cause notice. We are saying that a show-cause notice could not be applied retrospectively. Prospectively. 2000, our actions, our properties were pertaining to a period when this act was not in force.
Which act?
The Benami Prohibition of Benami Properties Act. Transaction
Okay.
Act.
Then
That we are challenging the show-cause notice. That's why it has come in the cinema.
there's a stay.
It was the stay was granted by this court only till the disposal of the writ petition.
So we shorten the stay then. If the matter is not taken up, why should we?
Lordship, it can be taken up tomorrow or the one month.
No, it doesn't help the court. Should we do as per your convenience?
No, Lordship, that's not the.
Don't you see there are a lot of other matters pending?
Lordship,
There are other matters pending. When a matter comes in the list, if I vacate the stay now, then you will have an urgency of doing the matter.
no, Lordship, we have never sought time for this matter on any other earlier occasion. In this case, the sections of the sections that has to be applicable or not applicable, that has to be looked into it. So I prayed that only for today. He is not well. Mr. Kane Chaudhary is not well. That's why I'm praying on his behalf.
You see, for senior counsel, I don't give adjournments.
I understand, Your Lordship.
Then
in this case,
impose a cost upon you
no, Lordship.
of 10,000 each in each writ petition. Mr. Dev Chaudhary, you are there.
SC Kyle is.
Okay.
I have taken the consent of SC Kyle.
Okay. So you pay him 10,000 rupees each as per cost. That has to be something. If you want it on some other day, when a matter is in the list, you have to do it. You can't say that you are not going to do it.
No, Lordship, I am not saying that, but Lordship, here since it pertains to the very provisions of Benami Transaction Act, now the senior counsel will be able to assist the court on.
Senior counsels are daily wages. They come. Nowadays, I've heard that they are hourly wages. So, what is the problem of that? You may have it or not have it. That is your lookout.
He would
But
have
I'm not
answered
going
he
to
is not
adjourn
well,
these
that
type
he
of
had a
matters. No.
throat infection, that is why he is not being able
I will
to.
fix it after 6 weeks, vacating the interim order. Then do whatever you like.
Then, Lordship, then it has to be taken up. If the interim order is vacated, then it will be infractured, Lordship.
Fantastic. Then what do you say? We should take it up?
Lordship, I'll try to assist the best of my ability, but the point is that if something goes wrong, then again.
Very well. We'll take it up.
For listing this case regarding the case, some partial lands are evicted by the state government in the name of Kurang National Park and Tiger Reserve. And
Motion matter?
motion matter.
You want to do it today?
This case,
You want to do it today? You want to do it today? When do you want it?
tomorrow morning.
Tomorrow. Yes, Mr. Talukdar.
Lordship,
You saw the calculation in that order?
yes, Lord, I have submitted before it.
No. Have you seen that order?
Yes,
That is not as per your calculation. Yes. Now tell me.
Lordship, this matters relates to acquisition of land, my lord. And due to interim order passed by the then arbitrator, Lordship, which the arbitrator post now has been abolished by the government, Lordship. So due to a portion of the interim order, Lordship, whole project of the national highway has been stopped, Lordship.
You want to
We
take
have
it
approached the,
tomorrow?
yes, my lord.
Please, your lordship. Lordship, I am praying on behalf of Advocate Amit Goel. Lordship, in the vacation, he went to Jharkhand, but because of some personal difficulty, he could not come. The
Hmm.
matter is part of item number 4, lordship. Any day after 11, lord.
Item number 4, release from Partha to be listed after the summer vacations, the puja recess.
Thank you, Lordship. Actually, I'm praying for listing of a contempt civil on Monday, Lordship.
Why?
Actually, what happened is, this honorable court had passed an order not to take any coercive action against daughter-in-law.
You have filed a new contempt
Yes, Lordship.
Monday.
Public.
Yeah, please, your lordship. I beg to mention an item for withdrawal. For withdrawal, lordship, writ petition has become in progress.
Which one?
It's a writ petition.
You want to file an application for withdrawal
Yes,
tomorrow?
yes, your lordship.
Please, your lordship, I beg to mention for listing a WPC for in orders.
For order?
Yes.
Why?
It is a village defense party matter where the petitioner was listed as number on the list. He was listed as number 1, but at the time of appointment, he was not given the post.
Okay, when do you want it?
111.
Not 11, 13? 13.
Yes, your lordship. I beg to mention one item for listing. That was just posted on 31st May 2023. Finally, the matter may be listed for order
15,
after 18th, if possible. Lordship.
Yeah. 29? 29.
Lordship, I think to mention one writ petition for motion tomorrow.
Today?
Tomorrow,
Tomorrow? Why?
because the petitioners were the elected member of the board of directors of the society. But on the basis of the complaint made by 2 individuals, their societies were dissolved and one-man committee was formed.
When was it dissolved?
I don't know.
Huh?
It was dissolved. I don't have the exact date right now.
When was the impugn order passed?
9/6, Lordship.
Okay, 9/6.
Huh?
9/6.
19th of
9/6/2023.
9/3.
6. 6. And thereafter,
Then what is
One
the urgency?
the one-man committee was appointed, Lordship, and one-man committee was directed to hold the election within 90 days. Lordship. So, on 11/8, Lordship, they have initiated the process of election. Lordship. The press election was proceeded, then the matter has become a
Which one?
present because if the election notification is stopped, Lordship, then we have to again challenge the second. Tomorrow, Lordship, I will say.
No, that order was passed on 9/6. Why were you waiting all this while?
Lordship, thereafter, one-man committee, subsequently, we come to know about something.
You were not aware.
So, Lordship, only.
One-man committee was appointed, and isn't it the mandate under 41(6) for appointment for holding the elections within 30 and 90 days?
That one-man committee was transferred, Lordship. He was person concerned was transferred, and accordingly on 11/8, a press new incumbent was appointed.
New one-man committee.
Yes.
No, we are not concerned with how many, which is the person concerned. It has to be a departmental officer. And the departmental officer was duly appointed. He was entrusted with the job of doing it.
But till that election notification was not.
Hmm?
Till that they have not issued the election notification.
Very well. What is the urgency tomorrow?
Then Monday, Lord.
Monday.
At number 1 for withdrawal.
You want to withdraw?
Yes.
Your name?
H. Rahman, Lord. H. Rahman.
Lordship,
H.
with
Raman.
liberty, Lordship.
The learned counsel appearing on behalf of the petitioner, Mr. H. Raman, submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Full stop. Interim order, if any, stands vacated.
Lordship, with liberty.
What liberty?
A talk of settlement is going on, Lord.
No. Settlement is there. It's a different question. You are withdrawing out there, withdraw. Where is the question of liberty?
If the talk of settlement does not resolve,
The learned counsel appearing on behalf of the petitioner further also submits that he seeks liberty to refile on the ground that there is a settlement going on. Taking into account that if the settlement fails, it would be a separate cause of action. The question of granting a liberty does not arise.
I don't know, 24 for withdrawal. Twenty-four.
Please, your lordship.
Want to withdraw?
Yes, your lordship.
The instant writ petition, the instant application has been filed for withdrawal of writ petition number 3450/2017 on the grounds mentioned in the writ petition in the application. This court, upon perusal of the above, grants the liberty to the petitioner to withdraw. Accordingly, the instant application stands allowed. I can allow that in view of the order passed in the accompanying interlocutory application, the instant writ petition stands closed on withdrawal.
Highly obliged to.
Item number 25 for motion.
Oh, it's a bad day for you. Ah, I gave you an opportunity on the last occasion on the ground that you have anything, there will be some other judge sitting who will be taking up the matter. But it again has fallen to my hands. You don't have a case.
we are finding an additional affidavit today. Can it be taken a bit longer?
What additional evidence?
Lordship, we have prepared representations before the register as well as the board of directors.
So we will register, the register will take, but the register can only take after the elections are over.
That is the difficult. Lordship, we have also prepared representation before the board of directors. They had not accepted. We had taken.
You see, isn't it absolutely an internal affairs between you and the board?
Lordship, what I am saying is that Lordship, we had.
How does, first explain to this court how a writ is maintainable?
Lordship, we have approached the register. Lordship.
No, how a writ is maintainable. The register doesn't come into the scene. The register only comes at a later stage.
Lordship, if I may,
Yes.
the rules, Lordship, provides that the it provides that the assistant register of cooperative society is concerned in exercise of the delegated powers shall ensure the correctness of the voter list.
Who?
Lordship, the assistant register of cooperative societies under the delegated powers by the register. Under the rules, Lordship, the cooperative society election rules 2019. Lordship, the assistant register is entrusted with the duty to check the veracity of the voters.
So?
Now, Lordship, that has not been done in the instant case. We had prepared a representation before.
When?
Lordship,
When did you prefer?
Lordship, we had prepared before the register on 1st of September.
When? When did you prefer?
1st of September.
The 1st of September, they will take care of it.
Lordship,
Why should this court at all interfere now?
Lordship, the only difficulty is that the voting is scheduled to be held on 9th.
So what?
Lordship, we had also approached the board of directors because there is a provision.
So what? That hardly matters. You go there.
Lordship,
This is not a court. This is not. What do you want?
the additional affidavit we have filed. Lordship,
You have a copy of it?
Lordship, we have filed it. That's not what we
You have a copy of it?
I do not have a copy right now. Can
You have one copy?
I have a copy?
You don't have a copy? Then we'll say that the additional affidavit has not been filed. I'll review after I dismiss the writ petition. By the time 9th will be over. You don't have a case. How is the writ maintainable, Mr. Talukdar?
If I may.
In view of SS Rana, the judgment. Writ is not maintainable. This is absolutely within the domain. You go and file a civil suit. Get an injunction. That is the only way out. Yeah, no, writ is maintainable now. Writ will come after once. First of all, I don't understand here also. Where is the question of according an approval under the Cooperative Society? It is absolutely between you and the members of the Cooperative Society. And the Cooperative Society, the Supreme Court has held out there, is not a state. This is internal. It is an internal dispute between you as well as the Cooperative Society or the Board of Directors of the Cooperative Society.
But under the rules, the register has to take the veracity of the voters list.
That he will look.
But
Later on, if he finds, you file your appeal thereupon. You file your appeal as per section 27. Rule 27, you file an appeal. The register will turn down everything if it is true. Why should this court at all interfere now?
may I pray that till the time the register takes the call upon the representation, the voting may not be occurred.
Absolutely no. You approach under 27. And if the register finds it, yes, the voters list has not been taken into account. You have a case out there. Thing to do with here. Hey, no, kita phone call. Hey, Talukdar.
Sir.
Where is your senior?
He's in lieutenant.
Huh?
He's in lieutenant.
Okay, at 2 o'clock. But you lose more time. This is surely going to get dismissed. There's no way out. But by then, if it is 2 o'clock, you get the order by tomorrow. You can't file an appeal. If it is now, you get an order by noon. You get an appeal.
Yeah, that's not bad.
But the fate is the same. 2 o'clock.
For admission, not heard.
Yes, madam. And have you thought anything about the 74?
Yes, sir. I have done a little bit of reading, and I think I am not covered by this.
You are not covered.
I think.
Fantastic.
So,
Show me how.
Lordship, initially, actually, I would like to place before Lordship what the inland container corporation is. It's not a consigner. It is basically it is basically Lordship. It does the footings on it. Has a Lordship. It's given in the Indian Railways Commercial Manual. I'll just give a copy of that
Hey, railway.
manual. Indian, I'll just give a copy. Photocopy. Lordship will look at clause 1476. 1476. Let's go.
Yes.
1476. ISO Container Service. Container Corporation of India Limited, CONCOR, is the Government of India undertaking under the Ministry of Railways and has been taken over the management operation of the ISO containers, including terminal activity for Indian Container Depot, earlier owned by the management of the Indian Railways. The ISO Corporation containers, marine containers, standard dimensions generated in 2 sizes for equivalent units and 40 units of descendants. Then Lordship will come to clause B. The Railway Board has authorized CONCOR to issue CONCOR Inland Way Bridge in view of railway leasing
and also quote and collect the charges directly from the cargo. So basically, it's a body which has been set up to manage the cargo. So it is not it takes the consignment on behalf of. Now, what happens not with contingent constitutional corporation, and they issue a inland way. Now, lordship.
So this inland bill will be a railway receipt. In terms of 65,
it cannot be it's 65.
as per 65.
As per 65.
Yeah.
So lordship, if I just take your lordship to this to the Indian way bridge, which has been in at page 36 of the new petition. That's in.
Yeah.
Is the thing, and lordship at page 37, lordship will find at clause 2, the inland way bridge given by Concord for containers to be carried by it and must be given the destination by the consignee at the time of taking delivery. But that, and lot number 3, the inland way bridge issued subject to the conditions and liability as specified in the Railways Act. So there's where they will want to draw 74 in. Now, lot people look at clause 4. The consigner must accept responsibility for particulars furnished in respect of the cargo tendered by him for stuffing in the containers and carried by Concord. The consigner is deemed to have indemnified Concord against any damage or loss suffered by reason of its incorrect or incomplete particulars by furnishing him while regarding the cargo, so which would include misdeclaration. Here, clause 4 gives the consigner the total. I'll take lordship to clause section 64. The clause is section 64 of the Railway Act. Forwarding note. Every person entrusting any goods to railway administration for carriage shall execute a forwarding note in such form as may be specified by the central government, provided that no forwarding note shall be executed in case of such goods as may be prescribed for some goods. 2, the consigner shall be responsible for the correctness of the particulars furnished by him in the forwarding note. The consigner shall indemnify the railways administration against any damage suffered by reason of incorrectness or incomplete particulars of the forwarding. That
But this number 3 is similar to number 2 and 3 is similar to 4.
4 of that. So the for incorrect, that is consigner's response. Section of the text. Now, lordship, what is a railway receipt? Under section 65, it says the railway administration shall, in case where the goods are to be loaded by a person entrusting such goods, on the completion of such loading or in any other case on acceptance of the goods by it, issue a railway receipt in such form as may be prescribed by the central government. A railway receipt shall be prima facie evidence of the weight and number of packages. So, railway receipt is confined to weight and number of packages. The lordship will come to section 73. Punitive charge for overloading of wagons. When a person loads goods in wagons beyond its permissible carrying capacity as exhibited under subsection 2 or subsection 3 or notified under subsection 4 of section 72, a railway administration may, in addition to the freight and other charges, recover from the consignor, the consignee or endorser. Now here the consignee and the endorser, but 64 and 65, 64 consignor was not, consignee was not. This is for the first time consignor and endorser. As the a consignor or consignee, as the case may be charged by way of penalty such rates as may be prescribed before delivery of the goods, provided that it shall be lawful for the railway administrators to unload the goods loaded beyond the capacity of the wagon if detected at the forwarding station or at the place before the destination station and recover the cost of such unloading and any charge for detention of any wagon on this account. Now, this is what the liability is fixed on the consignee and endorser. Then 74, of course, Lordship, that was the property in the consignment covered by the railway receipt shall pass to the consigner or the endorser, as the case may be, and delivered and delivery of such railway receipt to him, and he shall have the rights and liabilities of the consigner. Now, what does this 74 envisage? Obviously, the rights and liabilities as stated in 73, not for the declaration, because misdeclaration is the total chapter altogether. Even in the various tariff railway commercial manual, the Railway Goods Act, I say, and there's one more there, it is clearly said about this, the goods tariff number 41, which is in force, that also lays down what is what. If I take your lordship to that, goods tariff 41, I will draw your lordship's attention to 123. 123. Declaration of goods. When
Yes.
every consignment of goods, when handed over to the railway for dispatch, must be accompanied by a forwarding note, which must be signed by the sender or his authorized agent, and must contain declaration of the weight description according to section 66 of the Railways Act 1989, and destination station, etc., of the goods consigned, and indicate the column provided for the purpose of the route by which the goods are booked as provided in Rule 125. Now, Lordship will come to clause 3 of the same thing, 123. A merchant and trader must satisfy themselves their packages are properly addressed in their forwarding notes, correctly written, as the railway accepts no responsibility or accepts no responsibility as the accuracy of either case, and will hold the sender liable for any mistaken or misdeclaration. Now, it's totally on the sender, on the consignor. And Lordship will again come to 126. Then in page 8, we have 126. Penalty for false declaration. If on arrival at the destination, it is found that the goods have been improperly described, and a lower charge, then that correctly applicable has been thereby obtained. The charge at double the goods that at clause 300x rate will be levied by the book rule as shown in the relative invoice. If the consignment of package charged at different rates, a group of packages chargeable at the particular rate, it is improperly described, thereby a lower rate obtained. The charge at double the class this rate referred to in subclause A above shall be applied on the group of packages in the consignment improperly described. In the if a material false account is delivered with respect to the description of the goods, the person who gives that false account, and if is not the owner, and if he is not the owner also, if on conviction by a court, liable to fine which may extend to 500 rupees or for every quintal of bag of quintal of the goods, and the fine will be in addition to the rate which the goods are liable. Now, the sender and the owner, if convicted by a court, here the court comes, because Otherwise, how to blame the owner straight away? The owner gives the to the consigner puts if the declaration, hence this caution. The the owner will become only liable when if it is unconvicted liable.
No, this 126 is an offense.
Once it's of course false declaration.
It's an offense.
Yes.
This is not a question of any other thing, what it has been mentioned out there. It is not a civil liability, which is otherwise have been imposed upon them
Yes.
in view of that particular notification. 126 is an offense.
Yes.
Once you have fined, you will be held to be an offender to that effect.
Yes.
That is why the fine is 500 rupees per quintal.
And
And
lordship, and this is also misdeclaration.
but in all said and done, are you saying that the consignor is not liable?
Consigner is that. What I'm submitting lottery for misdeclaration, 64 comes into play, not 65, 70, and 75. There's a reason behind this lottery. The Supreme Court in one of the cases has said that if for overloading, that was a question of overloading, it was challenged on the ground that the consigner book and is violative of Article 14. The Supreme Court held that when you accepted the wrong goods, I mean the overloaded goods, you took more, you got more, you got benefit out of it. So now you cannot come and say that it is violative of Article 14 because you are also a beneficiary, and for overloading consignee is liable. But Dr. I take Dr. 2 in section 66 of the wages, when a consignee will become responsible for misdeclaration. That is when he gives a declaration, the consignee gives a declaration. Dr. Page section 66. Power to require a statement relating to description of goods. The owner or the person having charge of any goods which are brought upon the railway for the purpose of carriage by the railway, and the consignee or the endorsee by any of any consignment shall, on the request of any railway servant authorized in this behalf, deliver to such railway servant a statement in writing signed by such owner or person or such consignor or endorsee as the case may be, containing such description of the goods as would enable the railway servant to detect the rate of such carriage. If the owner or person refuses or neglects to give the statement required under subsection 1, refuses to open the package containing the goods, or that is not relevant. The third, if the consignor endorsing refuses or neglects to give statement as required under subsection 1, refuses to open the packages containing the goods, if so required by the railway servant, it shall be open to the railway administration to charge in respect of the carriage of such goods at the highest high rate for any class of goods. Now, if the consignee had given a declaration under section 66, then I would have been tried.
No, 66 will be at a stage. The declaration is in regard to Lease. 66 says that the owner or person having charge of any goods which are brought upon a railway for the purpose of carriage by the railway, and the consignee or the endorsee of any consignment shall, on the request of any railway servant authorized in his behalf, deliver to such railway servant a statement in writing signed by such owner or person or by the consignee or the endorsee as the case may be, containing such description of the goods as would enable the railway servant to determine the rate of such carriage.
So there has to be positive act on the part of the consignee. In this case, if no one says that I filed a declaration under section 66, what was given was a declaration by the consignee.
No, here the consignee or the endorsee makes the declaration on behalf of the own consignor.
Yes, but here is not the case. Everything was done by the consignor. I do not think this is absolutely not applicable.
Let us take an example. The consignor makes various false declarations.
Right.
He sends the goods.
Right.
And thereafter on, the consignor is nowhere to be found. What to do? Can the railway now release those goods? The railway has an option to ask you to give a statement.
Railway,
And if you neglect to give a statement, the railway has the power under 66(4).
yes, if I neglect to give a statement.
Yes.
And I do not give a statement, here no statements were ever asked. And if I give a false statement, my statement must not only be just a statement, it must be a false statement. If instead of iron ignore, I give sponge iron or vice versa, whatever, and the container contains something else, then I become responsible. Because giving there's definitely a case of mens rea is definitely here. I must actively, knowingly, willingly, deliberately give a statement. Then I become responsible. But that is not the case here. It is no one's case that I had given a false statement. It was that the consignor had booked, and the Concord had recognized that. Because in the first few demands, they have asked only reliable sponge to make the payment, because they made some false declaration in respect of others. But as far as I am concerned, there was no false declaration even by Reliance, and Reliance went and got an order from the Odisha High Court, where he got it amended further and said that the consignee may also give a back guarantee. I am not a party to this. I am not bound by this. Now, what happens, Lordship? 64 and 64.
But wouldn't that be an internal dispute between you and the consignor?
There's no internal dispute.
Yeah, absolutely. He has put you into this position.
He has got into his position, but I'm not bound by it.
No, he has sent the goods.
He has said,
You have made the payment to him.
yes,
And for that, he has transported or sent the goods to you.
right.
He had made a false declaration.
Yes.
And because of that, you are put into this problem.
No, a false declaration, not in my case.
Not in your case, but in some other case, but he knew it very well that there is a policy. If there is a false declaration is being made in one of the racks also, the entire rack will be penalized by 3 times. He knew it. It is don't you think that it will be between you and the consignor?
My respectful submission, no. Because this, I am not liable to pay at all, whatever. And whatever goods have come to me, correctly described, the correct rate has been obvious. So what is the illegality was committed by the consignor in respect of other. The container corporation has the option of imposing a fine of it, has the option of blacklisting. That option also the Railway Goods Act gives the Concord. It's not that they are left without any remedy. They have the remedy. And Lordship, even in
But whether blacklisting will allow them to get the money?
money,
If the goods are now released to the consignee,
money they will get. No, consignee, if I made a false declaration, kindly don't release the goods.
no, not you. A person at whose behest, at your behest, the consignor sent it.
Lordship, there is an amendment to the Rule 126 by Rate Circular number 95, where also I have given a copy dated 8/11/2006.
Hmm? Yes, penalty for false declaration.
Yes. That's one this amendment. Lordship, if on arrival to the destination, it is found that the goods have been improperly described, then a lower rate than the correctly applicable has thereby obtained, the charge 4 times the applicable freight rate will be levied on the book route shall be shown on the related invoice. This penal charges will be in addition to the freight charge, and this is this. If a consignment of packages charges at different rates, a good of packages chargeable at a particular rate is improperly described, then a lower rate obtained the charges 4 times applicable freight rate referred to in subclause A shall apply only to the.
So
group
you are
of
saying about 126, 1B,
1B.
wherein it says that it shall only apply to those improperly described. Only to the group of package in the consignment improperly described and not to the entire consignment. This is an amendment which was brought when,
This was in 2020, 2006.
and you are challenging which one?
No, this I'm not challenging.
No,
I'm
no,
challenging the
no,
rate
this
circular.
you are not challenging, but
I'm saying challenging the rate
this
circular.
is rule 126 of what rules is this? Of Goods
Uh,
Tariff Act.
Goods ticket.
So this has come pursuant to this impugn notification.
This was earlier. This was earlier because mine is 2000. I have 2011.
Oh,
This was earlier.
thereupon this has come.
Yes. So this has come. But anyway, my point is that I am not liable because of section 64, 60, and 73 and 70. Otherwise, what would happen, Lord? 64, Lord, people find the liability has been cast entirely on the consent. 64.
But how do you take care of 73?
73 is 73 talks of punishment for overloading or wagons.
No, 74.
74 lordship, because this, if lordship brings into the ambit of 74, even misdeclaration, what would happen? This section 64 would either be made negatively or it will be meaningless, because legislature was very particular to see that 60, when it came to misdeclaration, only the consignor was responsible. Hence, there's no mention of consignee in 64.
No, there's no mention of the consignee, but the consignee comes into the picture by 74.
74, only by 74 and 74.
Can we say
is-
that the 74 is useless?
No, 74 is for overload and overloading, loading,
Huh?
and more package.
It doesn't say anything about overload. Does it say?
No, it
The
talks about,
property in the consignment covered by railway receipt shall pass to the consignee or the
Yes.
endorsee as the case may be on the delivery of such railway receipt to him, and he shall have all rights and liabilities of the
Yes.
consignor.
yes,
So it is not for overload. The entire property is
No.
transferred to you on the basis of 74.
then 65 2 says what? 65 says railway receipts shall be the prima facie evidence of the weight and number of packages stated here. It is confined to weight and number. The classification is, categorization is in the stuffing report. Stuffing report deals with the categorization.
Because 64 also does not say anything about description.
64 talks about misdeclaration.
Does it say?
Incorrect is section 64(3).
Responsible for the correctness of the particulars furnished by him in the forwarding note.
Exactly. And
The
what is
consignor shall indemnify the railway administration against any damage suffered by it by reason of incorrectness or incompleteness of the particulars in the forwarding note.
Exactly. And forwarding note is what? Forwarding note is the stuffing report, which says what has been stuffed. The description of the goods. That is the stuffing report.
Do you have any judgments that 74 cannot be brought in regard to misdeclaration?
No, I have a judgment of 74. Why the way they justify 74 has held to be valid, because the court held that 74, when you take a overloaded consignment more than what has been declared, what the consignor doesn't lose, consignor stands to gain, because he has gained by way of the excess weight which he has
Let us
got.
see the judgment, what you are saying.
Lordship, if you look at paragraph 42. In our view, contentions are not tenable, as has been noted in the discussion point 1 and 2, the railway statute define maximum.
Madam, what do you say about para 37?
Yes, Doctor. Collector 74, liable of the consignment passing onto the consignment. Not only the rights, but also the liability. In view of the liability, section 73, under section 73 of the overloaded wagon,
No,
includes
para
liability
para
under section-
37,
Yes.
there are two answers to the contentions of the appellant. Firstly, section 73 clearly states
Yes.
that the penal charges can be collected from the consignor, consignee, or the endorsee as the case may be.
Right.
The words "as the case may be" occurring in section 73 and 74 have also to be explained. The consignor shall be liable for the penal charges even at the stage of delivery of the goods at the destination if he has booked the goods for sale.
Right.
The endorsee will be liable if the delivery is applied for at the destination by the endorsee. The consignee will be liable if the delivery is applied for at the destination for the consignee. Thus, the above section therefore expressly permits that these penal charges to be collected from the consignee also. Secondly, under section 74, once the railway receipt is delivered to the consignee, not only the rights of the consignor, but also the liabilities of the consignor pass on to the consignee.
Yes.
In our view, the words liability in section 74 includes the liability of the consignor to pay the penal charges under section 73 in respect of the overload goods covered by the railway receipt. So that is not only as regards overload, all others also, but it also includes overload. That is what is being meant.
But then what happens to section 64? 64, which is a very, very specific, where it only mentions the consignment.
64 says that it is the consignor who has to be responsible.
Correct.
But the moment you have the railway receipt being given for himself, then obviously it is the consignor. But if it is given to the consignee, then in that case it will be the consignee.
But then again, so what about section 66? Section 66 for misdeclaration makes the consignee, endorsee, anyone a party only if he has given a positive statement in writing as required. So the element of misdeclaration is there. And for that misdeclaration, if the consignee has not has got the correct good, is not responsible. Unless.
Does it say that the consignee is not responsible for misdeclaration in 66? No.
66 only,
66 is more of a procedure.
no, Lordship,
Yes.
because after 66 it follows.
Kindly read 66. It is when there is a description, it is actually the consignor has made the misdescription, and thereupon the consignee or the endorsee may be asked or any person on behalf of the consignor to make a statement,
So
and
if
the
I
statement
say-
thereupon has to be made.
If I make a statement, if the owner or Lordship is consignor, then Lordship will come. Is S4, if the statement delivered under subsection 1 is materially false with respect of the description of goods which purports to relate, the railway administration may charge in respect of carriage of such goods as such rate not exceeding this. If a difference arises between railway servant and the owner or person or consignee, as the case may be in respect of description of the goods for which the statement has been made, the railway servant may detain and examine the goods. Where any goods have been detained under this, the cost for detention will be taken. Lordship. Now, Lordship also will look at 114, this is the 114 of the goods tariff of the railway commercial tariff, 1/4.
Now, what is being challenged out there at Orissa High Court? What is being challenged?
Lordship, I am not a party to only say. I do
Yes,
not know him.
you are there. You are a party. Kindly come here.
The main case is not.
No, Mr. Sharma, let's hear you from here. Yes.
Lordship, they kindly peruse page 69, Lordship. Herein, Lordship, the Orissa High Court.
Page 69 of
has a
what?
Specific order.
Order is there, but
The new case, Lordship, 1974 of
Yes.
2020, Lordship. This
This is, I'm not on that. This is an order of bank guarantee the consignee can give. That's another aspect. I'm not on that. But what is the case being filed in Policing? Where a party of, you must be knowing,
Yes, Lordship.
what is the case by?
As per my instruction, Lordship, it relates to the misdeclaration itself, Lordship, and therein the consigner, Lordship,
What is the challenge made therein?
that they have not misdeclared, Lordship. They have not misdeclared. But the whole petition I am not carrying today, Lordship. The prayers made therein, Lordship, are not with me. In the next day, if possible, Lordship, I may be allowed to produce, Lordship, if required, Lordship.
How much, madam, you have to pay now?
No, I think they have not got the specific bill because I refuse to pay.
It's something around 3,27,000.
Something like that, Lord. Lordship. Lordship, as per my instruction, as of 2/12/2006, Lordship, the charges were around 6,41,300. 2016, Lordship. That
Huh?
was at that point of time, Lordship. It was in 2016, Lordship. The charge was around 6,41,355.
Why it has been put out here? That has been challenged out here, na?
They say this different, Lordship, 3 lakh something.
We are concerned. Kindly come to page 35 of the earlier petition.
Yes, 35. Lordship, the interest rate is also being.
Here, the consignor is the Reliable Spawns Private Limited.
Yes,
The total is something to that effect.
Yes.
And how much is for the petitioner?
that has not been given to me, Lordship, because I have not taken anything.
Huh?
Because Lordship it says
How much you have imposed upon the petitioner?
in respect of the 10 containers, Lordship, as of 2/12/2016, it was Lordship 6,41,355, Lordship.
Hmm?
That was the instruction received at that point of time, Lordship.
3 lakhs?
It was 6,41,300.
No, no.
55 lots.
Is it for the entire one?
No, it's only for the 10 containers, Lordship. For us,
No, we are concerned with the petitioner. How much?
that 10 containers only, Lordship.
So there was no misdeclaration there.
No, Lordship, actually, Lordship.
I understand what you want to say. You say that the other containers, there was a misdeclaration, but it has to be taken as a whole.
No, Lordship will kindly.
Are you saying that the petitioner's containers were also had a misdeclaration?
Lordship, I will clarify that, Lordship.
What is there to clarify? All along, there was nothing to that.
Lordship, there were 80 containers altogether, Lordship.
How many?
80 containers altogether. Out of that, Lordship, 49 were booked by Ma Bhavani Transport Service, Lordship,
Hmm.
and 41 were booked by Reliable Sponge Private Limited.
Hmm.
Lordship, in terms of the circular, the notified items needs to be only 30, Lordship. If it is more than 30, Lordship, then the rates are different, Lordship. In this case, what had happened, Lordship, both these consigners, Lordship, they misdeclared it to be probably 63, Lordship. That is their, Lordship. Lordship will turn to page 94 of the new petition of 2020.
And who is Mahavir Fellow Alloys Private Limited?
That is one of the consignee, Lordship, similar to that of the petition.
Why they have been made a party out here as a respondent?
No, he is the manufacturer. Oh, he is the manufacturer. He is. I'm
And
sorry.
the transporter was Reliable Sponge.
Reliable Sponge.
Okay, now
Lordship will turn to page 94 once
of
of the WBC of 2020, 1974 of 2000.
no, come to the old one. What is this?
Because the specific,
The case which was filed by that Reliable Sponge is an application challenging the action of the opposing in imposing penalty on the ground that the same is illegal. Quashing of the letter dated 23/11/2014. This is 23/11/2014. 22/11/2014. Bearing numbers 0 to 4. 2015 penalty. Where's the penalty chart?
Yes, so there was capital desire part.
Kindly come to page 90, running page 90 of the old petition. Annexure page 9 of the affidavit in reply. We have conducted physical verification of the container who arrived from so and so in front of the authorized agent of the party and our security personnel and found that 63 TUS were stuffed with billets and ignored, which comes under the notified commodity, and 17 TUS are sponged iron.
Right.
Amongst the 63 TUS, 30 TUS were declared as ignotes and billets, and the rest were declared as sponged iron. But commodity is found billets and ignotes. List of containers are attached. Now, as regards the petitioner herein, at page 10 or running page 91, you find
Issue
10. Billets and ignotes.
That was what I was saying, Lord. 63 containers.
What has happened to those goods now? Does these goods remain? Huh?
The tariff rule.
No, goods. Are the goods in the proper shape?
I don't,
9 years have gone by.
I don't know.
It must have rusted, Lordship.
Huh?
Rusting has occurred. Okay.
I've been moving in heaven and hell to get this case done, Lordship.
Hmm?
Either the council is changing or something is happening or instructions don't come. Just let it.
You have paid the money to your consignor, no?
Yes, I paid all payments happening.
You have paid the money.
Everything. And Lordship will find that in the tariff manual, as well as the sections, the Railway Act, they have made a distinction between overloading, 4 packages, and misdeclaration. Because here 65, 70, and 74 are club. But when it comes to 66, Lordship, the penal provision is at 163 of the railway. Because 66, I will come in if I give a declaration, which I have not yet known what this case. So I will come in only if there is a declaration unspecified for this misdeclaration. Otherwise, I don't.
Madam, I'm not thinking about that. The fact that 73, 74, they duly takes care of that. I'm only trying to
But
see
Lordship,
how your interest can be protected, taking into account that the matter is pending in the Orissa High Court.
Lordship, that was the excuse since that time.
Hmm?
Since the first time they came to the Orissa High Court.
Hmm. Because you see, the dispute, maybe whatever it is a dispute between him and the consignor.
Absolutely. And
The
bucket
consignor is not represented before this court, although they were put to notice
in the
earlier
court
one.
case, they were there.
It may always compel their appearance, Lord, because they misdeclared it.
Now, if the writ petition in Orissa High Court is allowed, what will be the consequence if you make the payment? There is nothing out there in the book,
83, Lordship.
unless you say that these consignment things are being mentioned out there in the book of how many wrecks are there. Or there is any mention out there in the Railway Act as regards to the matter is pending in the Orissa.
Lordship, 83.
How do you take care of that situation?
I hold a lien on the goods.
Hmm?
I'm not denying that.
No, you will hold the lien, okay. Just for example, if this court, let us assume that this court gives a direction that the petitioner will be given a liberty to pay that amount to which they are due, and for that you will release it. What happens in the Orissa, if the Orissa High Court, the writ petition is allowed, what happens then?
I'll have to refund it. Pending. গ্যারান্টি দিয়ে আপনি মানে
There is no prayer also of used for a direction upon the respondent number 5 to make the payment. And I can't pass that in view of the pendency of the Odisha High Court.
But even now, if this liability would include even the liability in the forwarding note, because 64 talks about forwarding road, 65 railway receipts, both are different. And both have,
Madam, 74, you have not been able to convince this court.
because Lordship, if their interpretation is given to section 74 with respect to submission, then what would happen? 64 would become negatory, which in
How?
this way, because 64 is only confined to the consigner. The legislature had something in mind when they made 64 only specifically the responsibility of the consigner and not the consigned. In fact, here also the consigner or endorser could have been brought it, but they have not. But deliberately omitted that. The deliberate omission of the
Let us assume what you are saying, that 64 says that, more particularly 64, 2 and 3 says that the responsibility is absolutely on the consignor.
Right.
He has to indemnify the railways.
Right.
Now, this indemnification, how do you take care of the use of the words out there that the rights of the consignor along with the liabilities of the consignor upon the handing over of the railway receipt passes on to the consignor?
Because Dr. This, when it comes to this declaration, there has to be definite mens rea. Intention.
No, for the purpose of mens rea
This
will be,
declaration.
no, mens rea will be only required only for the purpose of a criminal offense.
But intention, the mental intention is there.
Absolutely, for a criminal offense.
It's a positive act. This is there.
But are you saying that mens rea can also be, has to be there in respect of a civil action?
The mens rea not mens rea per se in the criminal context, but a positive act of the person who has given this declaration. Knowingly, willingly, intentionally has given this declaration.
Okay, let us assume what you are saying. Are you saying that for overloading,
For overloading, yes, Lordship, for overloading also,
who has done that?
the consigner has done that, but Supreme Court in that case, Lordship, would we look a little below at 47, I think, paragraph 47. Supreme Court has justified, has said that in case of overloading and more packages, what happens? Even though consignee is not responsible, but by taking delivery of the goods, the consignee derives benefit out of it, of the overloaded goods. Profit will come at the paragraph 47 towards the end.
Yeah.
Paragraph 47. Further, the question of reasonableness
Where?
of the
Para 47,
47 towards the
47
end,
says about the discussion here has also to be split into two parts. The period covered by the new act and the period under the old act.
No,
You are
Lord,
referring to where?
what is now the subject of penal charges? Come a few lines below, I think the 10th line. Subject of penal charges is the excess overweight above the permissible level stated, which is always below the maximum limit. In our view, the level under section 750 of the new act and rule 161 is intended for dual purpose. One, to see that the gross weight of the axle is not unduly heavy, so that accidents on account of axle breaking down could be prevented. The other reason behind the collection is that in as much as the wagon has carried such excess load up to the destination point, at the other end, replacement cost of the coaches, engines, rails, or repairs of bridges to be covered. In our view, the extra rate is higher rate that is something like a surcharge for the excess load to meet the said extent. Therefore, we do not think that a principle of delinquency is ingrained in this levy. In levy in this case of a breach of civil obligation under the FAIR. Though it lordship will come a bit down, then the court has said. Further, the question of reasonableness of the quantum of such extra rate cannot be challenged before us, and the appropriate forum would be before the railway tribunal. Rule 161 can therefore be resorted to for collection of these penal charges from the consignee also. After all, the consignee had received delivery of the overloaded goods and used the same for their business, commercial or industrial purposes. For such reasons, a statutory provision like Section 760 or Rule 161A, which permits levy of such a consignee, cannot, in our view, said to be arbitrary or unreasonable in the context. Now, this is not if the consignee gets a benefit, but what happens to me?
Fine.
There is no deliberate act on my part. And lordship in 64 and 66, there is a positive act. Hence, there is the liability has been made that way. But
Madam, you are reading 54, 56. These paragraphs are not here in this judgment which you have given.
lordship 47, I read 42, lordship.
You read 40?
Two.
42 starts in our view.
It is lordship will come down. 42 comes down.
In-
below the
Does it
dotted-
start with, in our view, these contentions are not tenable?
Yes, lordship.
Okay.
Then lordship will come below why they say page 148. Before us, the appropriate forum is this. Rule 161 can therefore be resorted to for collecting these penal charges from the consignee also. After all, the consignee had received delivery of the overloaded goods and used the same for their business, commercial or industrial purposes. From the above reasons, a statutory provision like 760 or Rule 161A, which permits the levy of such on such a consignee cannot be viewed in our cannot be in our view said to be arbitrary or unreasonable. So this is the logic. But if this analogy cannot be applied in my case, so at the same time, 64 and 66 has to be distinguished from 65. 60 and because this talks about the forwarding note or the stuffing report, and 65 is railway receipt. And railway receipt is evidence of what? Evidence of weight and number of packages. And because otherwise it would amount to reading more into 64, which is not permissible again. In that case, I'll rely upon the 1959 Supreme Court, where with two sections, if there's conflict, there has to be You cannot ignore one. That would be ignoring 65. Where responsibility has been. 65 responsibility has been fixed on the consignor.
Yes, what is the judgment?
Yeah, I've given the no. By the gender judgment, it's about the income tax. Income tax, well, yeah. The income tax, sorry, doctor. Yes, about the income tax, the two provisions of the Income Tax Act were challenged. 18 and 28. And yes. Paragraph 9.
Madam, what was your agreement between you and the consignor?
That, actually, there was no,
The consignor was different. That is response number 6.
yes, actually, there was no agreement between me and the consignor.
Between you and Reliance Phones, there is no nothing.
What was the contract? The contract was between the Mahabir Alloy, who is a manufacturer. I placed my order there, pay all the money, including the consignment. He has his own consignor, and the consignor has the goods. And after the goods are fixed, they send me the.
So the liability will be of Mahabir.
Yeah, the owner may also come in, but not me.
No, that is the liability will be the consignor will be Mahabir or Reliance Phones.
Reliance Point is the consignor. He is the consignor working for Mahabir.
He's a consignor.
The consignor, reliable for the consignor. He's one of those. Also, I'm also relying on this. On 19
Consignor is Reliance Phones. AC Mahabir Ferro Alloy. And how much do they have to pay?
As on date, lordship, that amount I don't have.
What is this Amazon date?
Because
You have to pay there.
Let's start with Emirates lordship now.
it includes lordship, some other taxes and service tax and penalty charge, both upon those charges, lordship,
How much does they have to pay? You don't know.
after some time, lordship, I'll get that instruction. Lordship.
Huh?
That I don't have, because that rates is being increased.
Because in view of that, this Indian Railway Commercial Manual, you stand in the footing of the railways. And being, as you stand in the footing of the railway, you also have the power to exercise on the 85, 86 and 87 of the Railways Act.
Lordship, there are two charges which are to be paid by the petitioner as of now. One is the differential freight charges, and the other one is 4 times the penalty of the 10%.
Understood, but what is it? Is it this amount which have been given out here
No,
of
no, lordship.
2311?
And
This one?
upon that, lordship, the interest is being levied, lordship.
Huh?
Upon that amount, interest is being levied yearly.
What interest? Where is the interest? Where you are saying that interest will be?
That's the reason why, lordship, the calculation as of.
No, where is the interest? Where have you mentioned that interest will be levied? Show me that term. Where is that communication?
Communication.
And you will be liable then to compensate the petitioner in respect to the loss of the goods? Will be liable for to pay for the compensation for the loss of the goods?
Because I hold lien, lordship, if there was a misdeclaration, lordship,
Understood. Misdeclaration is by Reliance, not by them. But I am asking you, where is the question of interest? Where is your demand? Show me that.
after Lordship, that in the affidavit,
I've seen your affidavit. Affidavit says that 28 other consignees have already taken by making the payment, except that the petitioner has only filed the case. This is your affidavit.
yes, Lord.
So under such circumstances, what is your basis of your interest? How can you claim interest? As you can claim interest only on the basis of this. The Railways Act. As per the Railways Act, can you impose interest? If your terms and conditions does not say, and it is an indemnification of an amount. And the interest calculation would be a subject matter of a different aspect, which can't be taken in this case.
Lordship, since there was a direction by the Orissa High Court to punish bank guarantee, Lord, when the
I'm
bank,
not concerned with the Orissa High Court.
Sure.
When I go to Cuttack, you tell me all these things. Now I am asking you here, where is the question of interest?
that is being charged by the bank,
No,
Lordship,
you
for
have to
the-
have the power. Where is your power to impose interest? You stand in the footing of a railway. Does the Railway Act stipulate imposition of interest? No.
that specific provision I can't say right now, but Lordship.
Why can't
that-
you say, are you not prepared after so many days of the matter being taken up?
There must be some provision, Lordship, by which the interest is being imposed, Lordship.
Show me your demand note. Demanded to the petitioner. How much the petitioner has to pay? Because your affidavits are not clear. That's nothing out there. On what basis you are saying, because you are imposing on the entire Reliance sponge of an amount which is 4 times will be 3,27,000. The total fare is 32,000 something.
Lordship, I'll have that instruction after some time, Lordship.
Where is the communication of 23/11/2014, which have been put to challenge before the
Okay. 20, 30, 34, 22/11, 30,
23/11/2014?
35 to 22/11.
Yeah. Kindly come to page 47. Imposition of penalty. How much is the page 47 of the new writ? Number of PU 41, difference freight 32,850, 4 times the penalty 3,27,800. Sales tax so and so. Total. How much this has come? I don't understand. Now, how are you putting it upon the petitioner? Because you have issued a communication. Look here. This petition at page 46. You have written a letter to this Lady Steel Industries regarding realization of penalty and other related charges against misdeclaration of commodity found in so-and-so rack on so-and-so. Please find herewith a letter received from the competent authority for withholding the till realization of the above charge, which is self-reliant. So this is the amount.
That was the amount at that point of time, Lordship.
So, show me out here, is it mentioned that interest will be charged?
Lordship,
Don't come to that line. At subsequent stage, if additional charges found to be recoverable, the same shall be collected. Don't come to that line. That is not interest. Show me the power of interest. The power of interest has to be statutory.
maybe Lordship, there must be some circulars, Lordship, based upon which this interest is being levied.
Huh?
There must be some circulars
Circulars issued by you.
issued by the railway authority.
The railways doesn't have a circular. You don't know about the circular.
Right
You
now,
want to invent a circular. Well,
since it specifically says, Lordship, that
procedurally
other
says what?
additional charges, Lordship, other additional charges, Lordship.
What are the additional charges and how much the petitioner has to pay? You don't know that.
As of 2000.
You have filed forget about 2014-15. You have filed an affidavit stating clearly that 28 consignees have already taken the delivery by paying the dues. It is only the petitioner who has filed the writ petition. Have you filed the affidavit or not?
Yes.
Then how much did the others pay? It can't be that the petitioner has to pay for the 41 racks.
No.
It has to be dependent upon how much racks it has happened.
I'm saying for only
The petitioner had only 10.
10, Lord.
Then how much does the petitioner has to pay?
There was a specific direction from this honorable court in 2016 itself, Lordship, and allowing them to really get their consignment release, Lordship. At that point of time, Lordship, the amount was calculated, and at that point of time, it was 6,41,000.
How does it 6 lakhs comes to?
Lordship, that some interest must have been levied, Lordship.
Under why? Where? Have you shown the calculation anywhere? 6 lakhs. If the freight was 32,000, how does the amount become 6 lakhs?
So come back, Lordship. Only sometime may kindly be granted.
Huh?
I'll put forward all the calculations, Lordship.
When?
Behind this amount. Lordship.
2 o'clock.
Yes, sir.
We'll have it on 12th. Get the calculations. And how much did the other consignees pay? And what is the power? Do you have the power for interest?
Lordship will kindly reflect that in the order, Lordship.
Why? You can't say
That will help.
to your clients?
I can say, Lord.
You have a voice. Tell your clients.
Please, Lord.
It's the matter on 12th of September 2023 for further consideration. At the top of the list. Gustav. On the said date, the learned counsel appearing on behalf of the respondent number 2, 3, and 4 shall apprise this court as to what is the exact dues that the petitioner has to pay for releasing of the consignment, as well as also what is the present status of the case before the Orissa High Court filed by the consignor. The learned counsel for the petition for the respondent number 2, 3, and 4 shall also apprise this court as to whether the said respondents would be entitled to any further amounts from the petition. From the consignor. I hope that is enough.
Lord, I have a prayer, my lord. Mr. S. Thakur is appearing for the private respondent, my lord. Unfortunately, he is not here today, my lord. He has prayed for an adjournment, my lord. Any date. As for convenience of this court. Maybe Tuesday or any date.
Mr. Bora, what has happened there in this case?
My lord, what happened, my lord, subsequent to that, though there's investigation was case, but the investigation, in spite of that order, was carried out by the police. So the learned trial court has called for a report from the police, and but subsequently he was exonerated. So he has initially proposed was issued to him. Thereafter, the charge sheet has been laid down. So you can see the page 60 of our reply dated 38/2023.
860.
Page 60
Yeah.
Annexure 6. So then thereafter the cognizance was
Then what happened after this?
charge sheet has been filed, my lord.
Where is the charge sheet?
Annexure, my lord. It's page 50, my lord.
What is the name of the company? Param Prakash Shah.
Yes. Page 50 Annexure 5, my lord.
Who are they accused now in this?
52 is the we have given the type copy also, my lord. Page 50 is the type copy.
Of the accused charge sheeted.
Yes.
You have been charge sheeted.
Yes. 58 is the relevant portion, my lord. Brief text of the case. We have typed it, my lord. Translated also.
You don't have a running page? Because nowadays
Running
we
page.
don't have those pages.
Running page.
Yeah, running page.
Running to it.
Page
It is 50 the type of it.
58. No, here the reply starts at page 60. Running page. Fire is here. Charge sheet type copy is Annexure 5. It is page 76. Now you have been charge sheeted.
Yes.
But recently a Supreme Court judgment has come.
Yes.
That even if it is charge sheeted
Charge-sheeted,
also,
yes.
it would not change the course.
Yes.
If no case is made up.
Yes.
That I have seen.
Para 11. And our contention is that, my lord, the annexure, which they are relying on in their second affidavit, my lord,
That is not a part of it.
it's not a part of the original FIR, neither it's a part of the charge sheet.
How can we come to know about that?
Yes,
aspect?
because every document, my lord, when it is filed along with the FIR, it has to be marked by initially marked by the CGM concerned. Here, there is no marking in that particular document by the CGM concerned. Neither it's a certified copy. Had it been a part of the charge sheet, it has to be a certified copy. And there is a contradiction also in respect of their own affidavit. The paragraph 3, very relevant for the purpose of this case. They themselves admitted that prior to the lodging of the FIR through the paragraph 3 of their additional affidavit,
Now, this is annexure 5 is the brief facts of the case,
Yes.
which is at page 76. Let us read this. The case has been lodged against the primary accused so and so, so and so, so and so. Received from the informant so and so. Within it has been alleged that the accused persons have cheated the informant of 10 lakhs in the name of giving job. Under investigation, allegations of so and so, so and so.
In the charge sheet, my lord.
In So now they are proceeding in terms with the Asian resurfacing. The judgment of the Supreme Court, Asian resurfacing. So there is no stay to that.
But when investigation was carried out, at that time, there was a clear stay, man. During the currency of the stay order, they have carried out the investigation. That's an admitted fact.
Mr. Counselor, how do you show that this document, which is there at page 53 or to page 57, is the document which have been accepted as the FIR or has been made a reference out there in the FIR?
No, the fact of the case is that whenever we are lodging an FIR, my lord, online FIR, only a specific space is given as regard to making the contentions of a particular person filing an FIR. So immediately when we come with that constraints word, when we feel only a substantial part of the statements are given there. Subsequently, after lodging of this particular FIR, I was called by the police to come and give a detailed description of this particular incident. I went to the police station, I have given a detailed description. In fact, the FIR which I have submitted subsequently, the written note, it was also uploaded in the website.
This is uploaded?
It is also uploaded in the website. And to my understanding, what I've received the instruction from my client, my lord, that if the case diary is called for, then the entire matter would be clear, the entire picture would be clear, because the deposit, everything has been done from Bokaro. And it is a detailed description. Now, I'm not saying that there has been suppression of facts or anything of that concern, but the certified copy which I has procured, there is no, that particular document is not there. Therefore, with my limited knowledge, I understand that.
The thing is like this. You have lodged an FIR by e-mode. After lodging of the FIR, there is a certified copy being given. Is this the certified copy which you are referring to at page 48 to page 52 of the running page?
No, my lord.
Yes, it is.
It is not a certified copy.
Huh?
It is not a certified copy, my lord.
It is not a certified copy?
This is a document which I submitted before the police station after lodging of this particular.
Have you looked into the document? Why you are saying it is not? Finally, see page 48, running page 48.
48 of their affidavit, my lord.
No, your affidavit. Do you have a running page or not?
I do, my lord.
Then
My affidavit ends at, my lord, 35.
it
Running
can't
page, my
be. Your affidavit, the new affidavit
The new
starts at
affidavit.
page, your new affidavit page starts at page 39.
lord. There has been some.
39 of the count.
Your additional affidavit which
My
you have filed on 28th of August 2023 starts at page 39. Because nowadays we don't have the other pages. We can't have it.
My lord is referring to page number.
48,
48 to
48 to 52. Oh,
48, I have certified copy, my lord.
so that is what. This certified copy was given to you when?
My lord,
Was it before the submission of that document or after
after submission of the document. After submission of the document.
this document?
Yes,
So this
Because-
document has to be signed.
my lord.
And if that is the document which you have placed
Hello.
after the initial filing of that FIR,
Hello.
because here if you see page 50,
My lord.
there is a scene out there
Yes, my lord.
of the CGM on 12/1/2016.
My lord.
Have you found it?
Yes, my lord.
So this is the gist.
My lord.
The FIR was registered on 10/1/2016.
My lord.
Now, when did you go to the police station to give this document?
15/12/2015, my
Huh?
lord. 15/12,
as per the-
15/12/2015.
So this was prior to that.
My lord. That's why there's a note as well, my lord. That the cognizance have been taken as regard to the submission that has been made in the online FIR, and the other document and the annexures are there along with this particular FIR. That note is there, man, in the FIR itself. Page number 50, my lord. It's a translation, my lord, of that particular note.
Where is the translation?
Page number
Page
50,
50.
my lord.
Huh?
Page 50, my lord.
40.
Mr. Counsel, you are not aware. You have not seen the papers properly. What is this page number 50? Page number 50 is the gist. It's a part of that FIR.
Yes, my lord.
Where is the translation?
51, my lord. I'm sorry, man.
So this has formed a part of it. So this aspect was uploaded
My lord.
on 15/12/2015.
Yes.
So when did you initially lodge the FIR?
My lord, my initial lodging of the FIR was
There's no date as such.
No, when you file an EFIR, there will be a date. Where, what is the date?
That's my understanding, it has to be 16. Posted on, logically page 50.
Page
50.
50. Yes.
There's a status open, my lord. Posted on. There's a date, my lord. 16/12/2015. So, as per this particular document,
So you are reading where?
Page 50, my lord.
Page, running
Yeah.
page 50.
Yes,
This is
where-
the page 50 is that particular gist.
Yes. In the
Where?
top, my lord, just where lordship has marked the scene.
Complaint number, name,
Left-hand side, my lord.
info,
1, 2, 3, 4.
Fourth,
posted on
yes, 16, 12, 15.
16/12/2015.
Yes.
So after he filed that handwritten one.
So it has to be subsequent to the 16. This handwritten one, because as his case that initially they filed it to online. That has to be on 16 as per this document.
Because this is written on 15.
Yes, then lordship kindly see their affidavit, paragraph 3, which is contrary. I have lodged an online FIR against the petitioner wherein I asked to submit a brief synopsis of the entire case therein a specific word limit. That's not good. Subsequently, on 15, how can it be a subsequent manner? Because the online FIR was registered on 16. So it has to be either 17 or 18.
Well, if I may
That
take,
was his posted himself.
if I may take my lord to this page, it must be 48, my lord. There is a note here assigned to PS date 15/12/2015, my lord.
Huh?
This particular page, my lord, which will be 48, if I'm not wrong.
50, 50.
48, my lord.
Yeah.
48. No, sir, it is 48. Okay, assigned date. Agor होता है. Okay, agor होता नहीं.
Assigned it to stay.
Assigned date is 15/12/2015, my lord. This same date. Assigned PS date.
Which one? Mr. Counsel, you kindly make it proper with your
My lord, my
records.
lord.
This
I'm
court
very sorry,
court
my
can't take up. You have these problems out there, you do whatever you like. This is not the way how you do it.
Sorry.
All these page numbers, we don't have those page numbers what you are referring to. Very difficult.
Well, that is the assigned date. That's a different.
No, the better copy of it is with them. Kindly come to page 67. Running page 67. And don't tell me you don't have page 67. This is the FIR. Where it is given, assigned. If we see this particular document, page 67, let's see the type copy of it. What is the type copy of this page 67? Ana में सूचना नीति 17/12/2015.
Annex of 4 maybe, madam.
Yes, Annex 4.
That is one posted on 16/12/15.
Huh?
Posted on.
Where you are getting put?
Top, okay, top, my lord, third, first column, third row, my lord.
There's a 43 complaint, district priority.
It from 20 to 20. 14 period. Ana में सूचना नीति 17/12/2015. No. Kindly see 3 core. Ana में सूचना नीति means on the date on which it was received on 17/12/2015 at 20 hours. प्राथमिक अर्ज करने की नीति 10/1/2016 1800 hours. Ana दैनिक type of information. Ana में This date is of relevance, page 67, running page 67, Annex 3-4. Aname Pras Kutushna Niti. That is on 17/12/2015. So this is the first date when it was received at the police station. Better you get your records properly.
I'm very sorry. I'm very sorry, my lord. I'll get it marked.
You have to be sorry.
Sorry.
This is not the way how you prepare it. Earlier, the thing is different. We have the page numbers, but now that page number is cut off. And how did you file it also in this manner? Because you have put your own in your index from page 35 to page 62. This is your index in the affidavit in reply filed by them. And interestingly, the additional affidavit you say from page 14 to 16.
My lord.
And how can it be page 14 to 16? What you have done is the writ petition finishes at page 26. Then the affidavit in opposition has to be thereafter, page 27 onwards. Page 27 to page 39. Then additional affidavit filed by them is on page 40 to page 60. And your affidavit in reply to the additional affidavit starts from page 61 to page 88. Taking into account that the records maintained by the councils appearing on behalf of the parties being not in order or not in sync with the records of the court. This court fixes this matter again on 12th of September, on which date the parties, the council for the parties shall, in the meantime, make their records in sync with the court records.
I don't know, 5 and 6.
Only, I would like to mention regarding the position of the petitioner, Milot.
You were allotted the
Yes,
plot
I left. referred to-
or the shop.
referred
You gave on rent to him.
to the plot.
Huh?
I was given the plot.
You were given the plot.
Paragraph 3, Milot. Your
Paragraph
Lord will see
3 of
annexed.
your writ.
A.
Which writ petition?
The first, the 21,
You are appearing for Arun Chandra Paul.
yes.
Page?
76, 21.
Paragraph 3, the petitioner got allotment of a plot number 86 at Kharuputiara on transfer of right and possession from Chief Kumar Sharma,
Chief Kumar Sharma.
measuring an area of 2 situated at Daily Market 2 by 20.
You often find the documents at page 13 onwards. Annex A.
It's 13 on.
Record indicate that the land on which the shop number 100 is located in the daily market Karupatia was allotted by the then chairman of the local board Mongoldoy against treasury Salan dated demand of 1954 and Salan dated demand 19, that is also 94. In the name of Patechan Saraugi Karupatia, and there is no due against him. Then
Page 15. Seeing the
page 14.
petition submitted by
It was
Shiv Kumar
from
Sharan,
Pakistan to, it was given to Shiv Kumar.
yes,
Shiv Karan.
Shiv Kumar to Arun
And
and Cohen
Karan to Arun Pal.
for ownership, the above. You were given the stall. Kindly come to page 15.
15.
Chief owner of stall number Iman. Yes, that is stall.
So you have been given a stall.
Measuring, your longevity.
Hmm.
Measuring 208 square meter. Oh,
Square feet.
220
20 square feet.
20 square meter in the daily
Huh?
market.
20 square meters.
Area is pointed out.
20 square meters.
Square meter.
So
And
20 square meters will be around 200 square feet, almost. Okay, so these 200 square feet of a stall was given to you. You are the owner.
fine.
Means you were given an allotment.
Yes,
And is it subject to payment of some revenue?
yes, no rent.
How much?
That was not very much, my lord, I suppose.
Huh? Anyway, so this was given to you.
Money
You gave it to him on rent
on rent.
to run it. And then you wanted to evict him. You filed a suit.
My lord.
You filed suit. It was decreed. It went in appeal. Appeal was dismissed and the revision was also dismissed.
I rent suit. Rent suit.
Huh?
Rent suit.
Understood?
Hmm.
So your suit was allowed initially. That
Then
was
it was
subsequently in appeal, it was reversed. And that was confirmed by this court under Article 115. So that ends there.
My lord.
So you can't evict them as of now as a tenant.
Fine.
So this is how the position stands. Now, in the meantime, there was an order being passed in the year 2013.
Yes, my lord.
May I clarify, my lord? He filed a suit for eviction, evicted the other person, my lord. We are. He filed a suit
Who are
for
you?
evicted the five.
No, Mr. Sharma, who are you?
And I am the, I
You are a municipal.
am under him, my lord.
No.
Taken the.
Who are you?
Position of Gumti, my lord.
No, Mr. So-and-so, who
I am
are you?
tenant. I was tenant.
Understood that. I've understood that.
Hmm.
Now, this is the first writ petition is filed by you. 5334 of
Yes,
2013 has been filed by you.
Yeah.
Whereby what order have you challenged?
That, my lord, that for cancellation of possession was challenged, my lord.
Where?
That was, my lord.
This one, page 42.
Yes, my lord.
You have challenged this order.
Yes, my lord.
Wait for it.
And that status
This
quo
is
is
to
there.
inform you that all undersigned authority in the board meeting held on so gone through the direction of the Honorable and writ appeal in this connection to resolve the dispute to Gumti so decided to vacate the present occupation by you as the same occupation is without having any authority of law. So you are asked to vacate your possession within 15 days from the date of receipt of this notice, failing which the undersigned authority shall have legal action against you. So you have
Sir.
challenged this.
My wanted to clarify, my lord, that the civil suit is in favor of me because eviction suit, my lord, earlier though there was decreed, my lord, in the appeal it was revised.
That is what
That
Mr.
is what court has said.
What I have said also.
Okay.
I have not said anything. He filed the civil suit to evict you.
Yes, my lord.
That suit was decreed, which was reversed in first appeal
Ah.
and confirmed in the revision.
Therefore, I am possessing.
Where have I come to a conclusion you are not?
Then-
I'm not. But you have challenged this order on 28th of August 2013, which is pending before this court. Now, while this order was pending and there was a stay being given,
Yes, my lord.
they give it to you.
Yes, my lord. That is, my lord, during pendency, that ought not to have done. That has. Because the case
Now,
pending.
what is
Because
your
the
authority,
status
Mr.
quo was there.
Chauhan? What is your authority to issue this communication of 28th of August 2013?
As per my lord, direction given by the Honorable High Court, my lord, and in a writ appeal, my lord,
Yes.
page
Prepare
27,
the
page 27,
declining to interfere with the order
Page
of
27.
regular cancelling the allotment of
page 27.
No, you see, you initially cancelled his allotment.
Yes.
On 5/11/2002.
Yes, ma'am.
That was put to challenge before this court. The single judge did not interfere. In the division bench, he made a submission to the effect that look here, this matter needs to be taken into consideration by them. And as such, what does the court do? In view of the stand without expressing, we set aside the impugn order and remand the matter to the executive officer for a fresh decision on the matter. The claim of the respondent number 4, 5, and 6 that they are in possession of the are entitled to continue may also be gone into by so and so in accordance with law. The parties may appear before the executive officer for further proceedings. So now there, the petitioners herein in this the old writ petition are aggrieved by the order by which you retain the allotment in his favor, but throw them out. That is the order which has been passed.
My lord, yes, 20.
Page 42.
August 13, yes,
Page 42.
page 42.
Now tell me, Mr. Chauhan,
Yes.
what are the conditions of allotment made to him?
My lord, initially, my lord, the one Saraugi, my lord, was my lord, initial LOT, my lord, that, but my lord, he, due course of time, my lord, he surrendered. He surrendered, my lord, to one Sri Kumar Sharma, my lord, long back. My lord, Sri Kumar Sharma, my lord, also did not run the, my lord, he surrendered, my lord. Thereafter, this fellow, my lord, was, his surrender was accepted and allotment was given. But my lord, dispute arise, my lord, when this petitioner, my lord, of new case, when my lord sublet the room. So such condition, my lord, sometime, my lord, this writ petition, my lord. has
No, okay. Do you have an authority that they can't sublet? Is it the terms of your allotment that they can't sublet?
My lord, I have no rule with me, my lord, but my submission, my lord, no, he cannot sublet.
How do
Because-
you say so? You have allotted to them.
Yes.
Can you say that they don't have a power to sublet unless it is a term of the allotment or on the basis of the statute or the rules?
That is the question, my lord, because
And that is the question, means that is the only question.
that is the question, because my lord,
Then-
the municipal board is the owner, my lord.
Eh?
Municipal board is the owner of the shop.
Understood.
Yes,
Now
because
you have to take a decision as to whether you want to give it to them or not. Now thereafter, what do you do? When this court stays it, you take a decision. No. Forget about Mr. Solia. Give it to him. That is it. And that is why the second petition has happened.
Right.
Now the fact that you have recognized the allotment made to him is not in doubt.
No.
Now, fact that whether he can sublet or not is another aspect which is not there. It can't be on the basis of your presumption or assumption or imagination that he cannot sublet. Or is it a case out there comes under the Transfer of Property Act or under the, because this allotment which is being made
Right.
is what type of allotment is that? Under what provision?
My lord, allotment, my lord, is the municipal corporation, municipal board, there, my lord, if they are own, my lord, land or structure, my lord, they everywhere, my lord, they, my lord, allot to different, my lord, persons, tenants, my lord.
Under what provision? This is done by the municipal board. Assam,
Municipal
under the what provision? Assam Town Planning Act or under the Assam Municipal Board? Municipal Act. It will be, it's a town committee. So Assam Town
My
and
lord,
Planning.
earlier town police, since my lord 2018, all town committee, my lord, converted to my lord, municipal board.
Now it is municipal board.
All are municipal board.
Okay, let us see the municipal act. So municipal act, Assam municipal. No, no, GM. Assam municipal. Is there any allotment letter issued by anybody?
This, my lord, allotment given to Mr. Aruchandra is not disputed. We have,
Huh?
my lord, this is not a dispute that he was not allotted.
From the allotment letter, one can find out
Oh, yes.
what are the terms of allotment.
No, my lord, letter is not available.
Do you have a right to realize any rent from them?
My lord, I have,
It's a municipal property. Mr. Sean,
my lord,
it's a municipal property.
property, my lord.
Hey, আমার পোকা লোকে লেখে। Anybody has a municipal act? municipal এখন নাই নি কেনেকে কয় হে আপনার Shocking. And all the lawyers have come out here to argue a matter on Assam Municipal Act, but do not have a municipal act. Isn't it the most strangest thing which is happening? And I have to see out here what is the right a person has under that act. Are you sure that it is under the Assam Municipal Act?
My lord, you,
Are you sure to that effect?
earlier, my lord, town committee. my
Mr.
lord,
Chauhan, are you sure it comes under the Assam Municipal
my-
Act?
my-
Previously, when this allotment were there, my lord, then it was a town committee.
Town committee.
And
Huh?
Earlier also town.
there was
committee.
a town committee, it was a town committee, and the municipal act provides that these rules are also being kept there also. There is a separate chapter.
Got it. Let me see.
James, one I have to-
But Mr. Solia, you don't have a right to have it for all purpose, for all time to come. You see, if it comes under the Municipal Act, Section 148 of the Municipal Act stipulates that it can't be for more than 3 years. How are you for perpetuity? Both of you are claiming the right over the municipal property.
Lordship may refer to 100, 101 and 102.
You have to show your right. No, not there cannot be an allotment in perpetuity. There has to be either a gift then. And the gift, the municipal commission doesn't have. Aruputiya Cow Committee is a
That notification is there, my lord, that, my lord.
It's a local self-government constituted under the provisions of the Assam Municipal Act 1954 or 56. There's another way.
Original was 54.
Huh?
Original act was
54.
no, 54, my lord, amended 2017.
Show me that.
My lord, in the second page, serial number 43, my lord, Cooperative Municipal notification is there. Serial number 43, my.
Mr. Chauhan,
Well,
you can't give this thing in perpetuity to both. It can't be. You have to enter into fresh lease. I set aside both and give you a direction. Neither he is the owner, neither him. Nobody. You take a decision. You have to allot it to somebody now. As per the section 148. You're a municipal act. You can't have it for all times to come. How are you giving somebody or recognizing to give it to somebody in perpetuity? See, this has been going on from 1990. How is it being done? How can a stall, do you have a right or can you give it to anybody like this? You can only lease out.
my lord, since 1993, my lord, both the party, my lord, they have been fighting themselves, my lord, filing, my lord,
Oh.
execution suit, my lord, and I was also party. Initial
You will
title
be
suit, my
obviously
lord.
a party because you don't know head or tail what has happened. You see, the problem is section 148. You have a copy of the Municipal Act? No. So, you're going to hide it. How can you give it for all times to come? See, section 148. There has to be an agreement. No agreement, nothing. Just they have given allotment.
But my lord, it is continue because of my lord, suit my lord, number of suit my lord, title
That
suit
is,
my lord.
that is the clever thing which they will obviously do. If they keep on fighting, you will say that why should I enter in between
Because my lord,
and lose everything?
I was made party, my lord.
You will obviously be made party. Because once, that means you are taking cognizance of it.
I'm sorry.
Mr. Solia, kindly show me, what is your authority to remain in perpetuity?
Because it says of land also. Because
So?
land, 148 million.
No, 148 says about land.
Yes.
Yes, what? Show me.
The board in a meeting may use their own land, building, or purchase or take on lease or otherwise acquire any land or building for the purpose of board
For the
in a
purpose of establishment of a municipal market,
market.
that is, the board may use their own land. That is, I'm not done. I'm on this thing. The board, number 3, the board may grant a lease according to the rules under this section for a period not exceeding 3 years for the collection of rent, toll, fees in municipal markets, parking plots at the rates prescribed by the board under so and so. A lessee of a municipal may appointed under subsection 3 may refuse to allow any person expose goods for the sale in so and so, so and so, so and so. Whoever having rendered to him the payment of rent, tolls, or so and so shall be liable to fine which may extend to 2,000 rupees. Then how can you for perpetuity give it to them? This is the power of the board. Granting of lease. This it has been held by this court. Where lease has been granted for more than 1 year, municipal board must grant the lease with the previous approval of the director of municipal administration. The word with the previous approval signifies that must be an act of thing which is to be done by one or acts of so and so as consented and ratified or confirmed by another. If the lease is to be made for a period more than 1 year, the board shall decide at least the period and the rent which would incite director to say that the proposal to the lease is approved. This is our court's judgment. Oh. Both the petitions are taken up for disposal by the common judgment and order. The disputes between the parties herein relate to a stall bearing number 100/86, measuring 220 square meters in the daily market of Kharupatia Town Committee, which is a committee registered under the provisions of the Assam Municipal Act 1956. It is seen from the records that one Petitions Saroge was allotted the land on which shop number 100 was located in the daily market Kharbutia by the then chairman, local board, against Treasury Challan number 18, dated 6/9/1954, and the Challan number 39, dated 20/10/1954. Thereupon, the said Fateh Sarogi transferred the stall to one Shiv Karan Sharma, and this transfer was approved by the then chairman Kharupatiya Town Committee, dated 1/3/1990. Subsequent thereto, the said Shiv Karan Sharma transferred the said stall number 100/86, measuring 200 square meter, 20 square meters of the daily market to the petitioner, to Sri Arun Chandra Paul, who is the petitioner, in WPC number 3076/2021. The record further reveals that the petitioner in WPC number 3076/2021 rented out the said stall to the respondent numbers 5, 6, and 7 in WPC number 3076/2021. It is further relevant to take note of that there were various litigations between the petitioner and the respondent number 5, 6, and 7 relating to rent dispute, for which the petitioner sought for eviction of the respondent number 5, 6, and 7. Though initially the trial court had decreed the suit in favor of the petitioner, but subsequently the said decree was reversed by the first appellate court, and the said order of the first appellate court was confirmed by this court in exercise of the powers under section 115 of the Code of Civil Procedure 1908. Next. While the above disputes were pending, the Kharupatiya Town Committee, through its chairman, to its executive officer, by an order dated 5/11/2022, cancelled the allotment of the shops made in favor of the petitioner. 2002. Cancelled the allotment made in favor of the petitioner. This cancellation was put to challenge before this court in WPC number
7073.
Hmm?
73.
70
73 of 2002.
7070
7070 73 7073/2000 2002. However, the said petition was dismissed by the court, by this court,
I ordered it 2/6/2009.
by order dated 2/6/2009.
Nine.
Thereupon, the petitioner preferred an appeal before the division bench of this court, which was registered and numbered as the WA 26/2011. The division bench of this court, by an order dated 9/10/2012, set aside the order dated 5/11/2002, passed by the executive officer of the Cooperative Town Committee, without expressing any opinion on merits, and directing the executive officer of the town committee for a fresh decision in the matter. The respondent numbers 5, 6, and 7 herein were the respondent number 4, 5, and 6 in the said writ appeal, who claimed that they were in possession of the stall in question. Under such circumstances, the division bench of this court directed the executive officer of the Cooperative Town Committee to take a decision afresh in accordance with law. And the parties were directed to appear before the executive officer for further proceedings on 20/12/2012. On the basis of the said decision, which was on the basis of the direction so passed by this court, by the division bench of this court on 9/10/2012, in writ appeal number 26/2011, the chairman Cooperative Town Committee passed an order on 28/2013, whereby it was informed, whereby it was mentioned that it was decided that the petitioner, that the respondent number 5, 6, and 7 herein should vacate the present occupation, as the said occupation was without having any authority of law. It was further mentioned that if the said respondent numbers 5, 6, and 7 herein do not vacate, legal action as per law would be taken to recover the possession of the Ghumti number 86. This communication was put to challenge by the respondent numbers 5, 6, and 7 herein as petitioners in WPC number 5334/2013. This court, by an order dated 13/9/2013, issued rule and in the interim directed status quo be maintained as regards the possession of Ghumti number 86 of Kharubatia Daily Market, with the liberty, however, given to the respondents to come up for modification, vacation, alteration of the order if so advised. It, however, reveals from the record that there was no modification whatsoever to the said order sought for by the respondents, who includes the petitioner herein, as well as the Kharubatia Town Committee. The status quo as regards the possession thereupon continued. although the matter was pending. Most surprisingly, though the matter was pending before this court, and there was a status quo direction, status quo order passed by this court, as noted above. The executive officer of the Cooperative Municipal Board passed an order on 18/2/2021 whereby the earlier decision of 28/2013 was reversed and it was opined that the claim of the respondent numbers 5, 6, and 7 herein be considered for allotment. It was also opined that the order of the executive officer of Cooperative Municipal Board dated 5/12/2002 may be allowed to withstand, may be allowed to continue. And the petition of the petitioner was disposed of accordingly. This order dated 18/2/2021 was put to challenge before this court in WPC number 3076/2021. This court, by an order dated 24/6/2021, issued notice and state the operation of the order dated 18/2/2021 passed by the Executive Officer, Karubetia Town Committee, till further orders. Therefore, from the said orders, therefore, it is further relevant to take note of that the said order said orders dated 13/9/2013 in WBC number 5334/2013, as well as the order dated 24/6/2021 in WPC number 3076/2021 still continues to hold the field. I've heard the learned counsels for the parties. Now, it further transpires from the records that in both the writ petitions, affidavits have been filed by the respondents, by the contesting respondents. I've heard the learned counsels for the parties and have perused the materials from the court. Upon hearing the dispute, hearing the learned counsel, it transpires that the dispute pertains to a stall bearing number 100/86 at measuring 200 square feet, 20 square meters, which was allotted by the Cooperative Committee was allotted by the predecessor of the Cooperative Town Committee, to one Petitions Saraugic, this allotment was thereafter transferred to one Sip Karan Sharma. And the said transfer was permitted by the chairman of the Cooperative Town Committee on 1/3/1990, subject to payment of the tolls to the office as per the rates prescribed and approved regularly. Subsequent thereto, on 7th of May 1993, the said Sip Karan Sharma again transferred the stall number 100/86 to the petitioner. That is the petitioner in WBC number 3076/2021. This court has put a specific query upon the learned counsel, senior counsel appearing on behalf of the petitioner in WPC number 3076/2021, as well as also to Mr. S. Chauhan, appearing on behalf of the Cooperative Town Committee, as to what are the terms of allotment, what are the rights which are conferred upon the allottee, and as to whether the allottee can again sublet nothing could be shown before this court except the orders by which the executive officer or the chairman of the Cooperative Town Committee have accorded the approval to the transfers so made from one allottee to the other. Taking into account that the provisions of the Assam Municipal Act 1956 duly applies to the Cooperative Town Committee, as it is a municipality within the meaning of it's a municipal board. It's a local self-government coming within the ambit of the said Act of 1956. It is the opinion of this court that sense any document being shown before this court, whereby the absolute rights over the stall in question have been transferred. The provisions of Section 148 of the Assam Municipal Act 1956 would be applicable. A perusal of the said provision would show that the rights so conferred upon the allottee or the lessee is not perpetual and hereditary. In fact, the perusal of subsection 3 of section 148 of the Assam Municipal Act 1956 would show that there can be no lease beyond 3 years. This court further finds it relevant to refer to a judgment of the coordinate bench of this court in the case of Sarat Kumar Neog versus State of Assam, reported in 1992 1 GLR 152. I'll come at 2. Under, as discussed above, the petitioner in WPC number 3076/2021 cannot be said to have a perpetual right, perpetual hereditary as well as a transferable right over the stall in question at measuring 20 square meters, bearing number 100/86. Now the next question arises as to what is the right of the respondent number 5, 6, and 7. Taking into consideration that such rights emanates from the rights of the petitioner in WPC number 3076/2021. In the opinion of this court, that as the petitioner also does not have, the petitioner being in WPC number 3076/2021 does not have a right and the continuation of the allotment so permitted by the Cooperative Town Committee is divorce the provisions of the Assam Municipal Act 1956 and the rules. No right, therefore, stands transferred or conferred upon the respondent number 5, 6, and 7 by virtue of by the petitioner. In WPC number 3076/2021. In view of the above analysis, let this court therefore consider the 2 impugned orders. The impugned order dated 28/2013, which the order dated in 28/2013, which have been impugned in WPC number 5334/2013. in the opinion of this court, does not require any interference. On the ground that no rights have been conferred upon the respondent number 5, 6, and 7 here, 5, 6, and 7, that is the who are the petitioners in WPC number 5334/2013 by the Cooperative Town Committee. And as such, the said respondent number 5, 6, and 7 has no right over the Ghumti / stall bearing number 100/86 in the Kharupatia Daily Market. Now coming to the order impugned. Order dated 18/2/2021, impugned in WPC number 3076/2021. It shocks and surprises this court as to how the said order was passed when the matter was pending adjudication before this court. Further to that, a perusal of the said order dated 18/2/2021 also show that there is no reasons assigned as to why the claim of the respondent numbers 5, 6, and 7 was required to be considered the horse, the other persons who may have a rightful interest or who may have an interest over the stall in question. It is a public, a municipal, the stall in question is a municipal property. And the same has to be settled in the manner recognized by law. Thereby, meaning thereby, that the settlement or allotment of the stall in question has to be by way of inviting applications from the interested persons. And not in a manner in which it has been done by the impugned order dated 18/2/2021. The say this court further finds it relevant to observe that the said order, impugned order dated 18/2/2021 is on the face of it arbitrary, irrational, and violates the mandate of Article 14 of the Constitution. Accordingly, the impugned order dated 18/2/2021 is therefore set aside and quashed. In that view of the in view of the above observations and observations, this court therefore disposes of the instant writ petition with the following directions. The impugned order dated 28/2013 is not interfered with. The impugned order dated 18/2021 is set aside and quashed. Number 2. Number 3. It is observed that the petitioner, that is, WP petitioner, Sri Arun Chandra Paul, does not have a permanent, heritable, and transferable right over the stall in question. Over the stall being stall number 100/86 at Karaputia Daily Market. And the continuation of the allotment and the continuation of the right of the petitioner over the said stall is in derogation to the provisions of the Assam Municipal Act 1956 and the rules framed therein under. Next. This court further directs the Karaputia Municipal Board to take necessary steps as per the Assam Municipal Act 1956, as well as the rules framed therein under, for settlement / allotment of the stall in question in a fair and a transparent manner, thereby inviting applications from all concerned. The same be done within a period of 4 weeks from the date. A certified copy of this order. You are there?
My lord, one difficulty is there, my lord. This Gumti is very, very old, my lord. Dilapidated condition, my lord. Unless they might vacate, my lord. It is clear. Unless it is a repair, my lord.
Okay, then it's itu dia. Itu agora can only that photo case number photo. Now, if the Karaputia Municipal Board proposes to settle or allot the Ghumti in question, I think that is enough. If you want to settle or allot.
My lord, the occupant, my lord, not paying rent, my lord. So we may be granted liberty, my lord.
Or
to recover, my lord, this whatever rent, my lord, leave rent they have not paid, but although running, my lord.
that you have it. Who has asked you not to? You are not the petitioner here.
I agree.
Why should I give you?
I agreed to pay the rents, my lord, but municipal board is not taking up.
It's okay.
Yeah.
Whatever it is, they will do it. That is it. Why should I say anything out there? That is none of your, neither you are the party out here, neither it is your case. I have given you, if you want to settle, you settle it.
My lord, status quo order operating, my lord, in this case, my lord, 13/5/33 for 13, my lord.
Huh?
Status quo order is there. Status quo order is there.
What?
Status quo order is operating, my lord, in writ petition 5334 of 13.
I had already approved your first order, thereby wanting to throw them out. I have set aside the order by which you wanted to give it to them. So, what do you mean? Isn't it over?
One clarification, my lord, because status quo order is there.
In view of the absolute number 5, in view of the order passed herein, the interim order so passed in the writ petition stands vacated. You can write.
Item number 25.
Yes. Your senior didn't come this time also.
Lordship, he wasn't feeling well today. He wasn't feeling well today.
Now I can't help you any further. Yes. What to do? Dismiss.
As regards the control lordship, the external judgment.
You don't have a case. You go under 27. After that,
Your lordship,
is the election held with your money? Is the election held with your money?
No.
Money of whose? The board? So tomorrow it is set aside, again it will be held. And there are many cases which I have come across. After 3-4 days, it is set aside due to the wrong, what do you call? The voters list not being proper. So the authority will take a call. Then let the other side come. If it is given in your favor. So what to do?
lordship may pass the order. Lordship may pass the order.
Dismiss. Better off, why don't you say that you have already submitted representation, and if anything is not done, thereafter you will approach under Rule 27, and thereafter they will take a call. I think that is the best option. If I say anything, I'll have to dismiss it. If I say something more than that. And I'll have to go into the question of non-maintainability, which Mr. Talukdar wants. Better you do that.
Lordship, but we have already filed the additional affidavit. We have served the copy. We have filed the additional affidavit, served the copy that we have filed the representation.
Where is that additional affidavit? You have got a copy of it?
I have got a copy.
You have a copy, give it to me. Hey, Mr. Talukdar, let me borrow your book again.
My lord. Yes. Thank you. Page 129 is the
You have requested the board of directors?
we have requested the board of directors as well
When?
to register for.
Why did you send it by registered post?
Lordship, we had made a statement. We had gone, they did not accept the representation. So we had no alternative but to send it to registered post again. We have made the statement, Lordship, on in paragraph 3, Lordship.
When did you give that?
Lordship. Lordship, first page approach on 30th of August, Lordship. We had
Huh?
stated in paragraph 3, Lordship, we had stated on 30th of August, 3008. We had approached, they did not accept. Thereafter, on 1st of September, we prepared before the register, and then again on 2nd, we sent it to register.
But where have you approached? Why haven't you mentioned in this communication?
That unfortunately,
Why haven't you mentioned? that you have approached them also. Why have you approached the register? Who is going to correct the voters list?
The overall control is.
Overall is forget. Overall, as per
assistant
41, it is the register who has to do it. I'm not on that.
Assistant
But
register
I am asking you, who makes the voters list?
the board of directors.
Have you approached the board?
But we had approached them.
Where? Why haven't you mentioned out there in the communication of 19?
But they don't.
Why? You have not mentioned it. Then why should I accept that? You should have mentioned it. Wouldn't that be the ground? And why have you sent? Where is that this? To the president of board of directors, Desh Bhakta Gaon Panchayat Samavaya Committee. No address.
No, we have enclosed the envelope as well on the net.
Where's the envelope?
Page 132, Lordship.
Fantastic.
But
Can anybody read what is there? What is there in that page 132? Mr. Talukdar, can you read what is there at page 132?
My lord, it is illegible.
Illegible. Illegible is a better word.
My lord,
Illegible is a better word.
my lord. Oh, that is, my lord, here it is illegible. There it is worse, my lord.
Well, Lordship, they have.
It's a black document.
Yes,
Which to the
Why have you sent? And what is the address you have put? Show me.
to the president, the estimated village, Naligaon, PO Naligaon, pin number 78135.
Then why? Where do you stay?
Lordship, that also stated the post office is within a distance of 500 meters from the office. However, till date, the tracking report
Then-
states that it has not been delivered.
When did you send?
It was sent on 2nd of September, Lordship, page 130.
2nd of September. There is no date. Why? In your communication?
Lordship, this was sent by registered, but this was the copy.
Page 130. Why there is no date?
Page 133. Lordship.
130.
Lordship, this was the copy which was with us.
Where is the date? You have sent it in SMS.
Lordship, may kindly see the registered post.
no, representation of date to court.
Where is the date of the representation?
Lordship, this was the copy which was with us, so the date wasn't mentioned. This was the copy which was with the petitioners. They did not.
They did not put a date. So how are we to believe this?
Lordship, if you Lordship kindly take the page 133,
And why didn't you send it prior to that? Prior to approaching this register?
Lordship, 30th we had went by hand, it was not accepted. So then.
30th you went by hand to give it.
Give it.
That being the last date.
That being the last.
You knew about the notification came up when?
Lordship, 20th, 20, Lordship.
Then what were you doing all this while? And on the last date of submission, why haven't you last date of the nomination? Why did you approach them only? That my voters list?
Lordship, earlier we had approached.
The reason is that you don't want that election.
Lordship,
And then thereby make them on default on the 39.
correct. That is correct. Lordship,
Where is that book? The learned counsel appearing on behalf of the petitioner submits that taking into account the provisions of Rule 27 of the Assam Cooperative Society's Election Rules 2019, he would not like to press the instant writ petition. He, however, submits that not pressing the instant writ petition should not in any manner prejudice the petitioners in exercising their right of grievance, exercise their rights under Rule 27 of the Assam Cooperative Society's Election Rules 2019. Taking into account the above submissions, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to approach the given to the petitioner, if so aggrieved, to approach the appropriate forum, including under Rule 27 of the Rules of 2019. It is further made clear that the withdrawal of the instant writ petition shall not prejudice the rights of the petitioner as regards the contentions raised in the instant petition.
much obliged.
Yes, you can take this again. But
That was
it
7.
will take some time for us to get hold of. We have a system.
Okay, so Lordship, my senior is on legs, my lord.
Huh?
My senior is on legs, my lord.
Who is on legs?
Mr. M.U. Mahmood.
What is it? What is this matter about?
Madam, this matter relates to construction of a Kalakshetra.
Huh?
Construction of a Kalakshetra, Narayan Kalakshetra in Bongaigaon district.
As to why the ongoing construction of Narayan so and so in the district should not be allowed to continue, and or to show cause as to why the pond within the said Kalakshetra area shall not be allowed to continue till its final shape in an appropriate manner under the supervision of the construction committee. Who are you?
I'm the petitioner here.
Obviously.
Uh,
Who are you? The petitioner.
S of petitioner.
Huh?
Oh, petitioner is the committee, all of them Post Rajbangshi Sanmilani.
Hmm.
And the second petitioner number 2 is the president, my lord. Here.
Then, what do you want?
Lord, if my senior here comes, then
Huh?
if I well, here the thing is that we are given land to construct a Kalakshetra. After that, meanwhile, while we are constructing that, we are not disturbed or anything. In the midway, the private respondent came in our land and then obstructed us from doing our work.
Obstructed you?
From doing our work. And
Then why are you before this court?
well,
Why are you not fighting out before the civil court? Not to get an injunction, not to obstruct. Has the respondent numbers 1 to 4 done any problems to you?
no, my lord, but the thing is that we have filed an FIR also in.
Then go to Sakira Basu. There's a judgment. FIR filing, how does it matter?
It's a matter.
All your senior. Huh?
Lordship,
I won't like to dismiss it in your hand.
Lordship, in this case, today I have filed our affidavit, Lordship. I am for the private respondent. Today morning I have filed our affidavit.
You want some direction against you?
No, Lordship, no.
Then wait.
Item number 8 for orders.
Yes, why it is for orders?
My lord, in the last of the notice was issued, my lord, and we are directed to take justice on the response number 4 and 5 method, which is existing.
Yes, today the matter was fixed.
Yes, ma'am.
Huh?
Yes, ma'am.
Why?
My lord, the last occasion interim was not considered, my lord. The issue is that, my lord, due to the freezing of the minor company's account, the labor payment was stopped, my lord. The Axis Bank response number 4 and many occasions asked for the documents from the petitioner company, and we have complied with them. In the last
Please
occasion,
verify that the bank account has been frozen by the response number 4 and 5 apparently due to non-compliance of know your customer norm.
KYC, re-KYC.
According to Mr. Caste, regardless of the fact that the KYC norms are fulfilled or not, the bank account cannot accept that it is their without prior intimation to the account holder. Has therefore prayed for an interim order directing the respondent to remove the suspension. Yes.
May please, your lordship. My lord, I am appearing for respondent number 3, 4, and 5, my lord, for the Axis Bank. My lord, very small issue, my lord, complicated by the petitioner himself. My lord, what is appear from the cost title, the petitioner has 2 addresses. Number 1 is at Letikuzan Golaghat. That is the register office of the company. And the other one is at Parag Bhavan Ulubari, 4th floor.
Oh, this case I can't take it up. Bogidala
Bogidala, my lord.
This is the matter before any other.
My lord, can it take up tomorrow, my lord?
I can't. This is the matter before any other. The petitioner is given the liberty to. Yeah. You approve the registry.
Yes, my lord. Because of the urgency, my lord, labor payment was stopped, my lord.
This is the matter before any other bench. It has been submitted by the learned counsel for the petitioner that there is grave urgency in the matter. He may approach the registry for listing the matter at the earliest.
Deeply
Obliged.
9 to 11 for hearing.
Yes, what is this?
May it be please, your lordship. Lordship, in this case, on dated 3/9/2013 and 6/9/2013, the Honorable High Court has been directed the railway to supply the weight of empty wagon before loading of the goods into then the order to suffice the loading purpose. The
Colombo.
actual weight of the empty wagons may be specified before loading of the goods, my lord.
Huh? Yes. So what is your grievance, madam? Why are three writ petitions together? All the three writ petitions have the same thing.
Yes.
Yes, my lord.
Huh? So what is the case? Tell me. Who, in which case you are appearing?
I'm appearing in item number 11.
Name
AJ Hadid.
that I know. What is the petitioner's name?
Sir,
You know the petitioner?
NRI code supply.
NRI.
NRI code.
Yes, what is the case?
Sir, basically we have challenge on notification. The process come.
Where is that notification?
The process come to page 26 of my.
Page 26. Yes.
Sir.
Design fair weight of vehicles for fixation of permissible carrying capacity in terms of the port.
This notification is of the year 2011.
Right.
But this notification still exists or not? We have no instruction.
Huh?
This notification still exists or not? We have no instruction.
I am appearing on behalf of item number 9, your lordship.
Okay, he's asking whether this notification remains or not. He has
As
no
my
instruction.
instruction in the morning time, these petitions already been in fax to us. Because this petition has been filed in 2013, now 2023. And so far the notifications are concerned, if any defective or any kind of errors, definitely it will come to before our department, concerned department. But there is no any pending on these issues. So my humble prayer before this honorable court that empty wagon issue, who were they alleged, that is not correct. And it has been already been substantiated as per the earlier circular. There is no any defective or any kind of any issues later on, subsequent after issuing of this railway board circular. There is no any kind of issues filed by the either petitioner or any other petitioner.
Whether other petitioners have not challenged it, does it mean that nothing is there?
Your lordship, here in this case, what about the notification? We have filed our affidavit. The stand is very clear and that has been clearly mentioned in our affidavit.
Then how can you say it to be infructuous? In the interim measure, whenever it is applied for by members of the prisoner, the railway will provide the actual weight specification of the empty wagon on which the coal is loaded. This is the interim order passed.
Yes, that is the interim order
So
passed.
are you following this?
Yes, your lord.
You say that you follow this. I'll make the interim order absolute. They'll be happy with it.
3/9/2013, that interim order in my case.
So
So
if
our
you want this 10/10/2012, that order, wherein this is a case filed by the Northeastern Coal Mine Association, whereby they are aggrieved through the railways are aggrieved by the notification dated demand which has made operational for mayor by the recent notification. To the impugned weight of empty goods wagons, stairways are specified category wise on beam basis without reckoning the actual weight of the wagon. The railway ministries have notified gross load limit of CC plus 62 of so and so. If no, A. Goel, the Learned Council argues that the railway authorities should not penalize any one of the basis of the designated demand, and the petitioner is prepared to pay the penal charges if they are found to overload by taking into account the actual weight of the empty wagon. In view of that, notice issued as an interim measure whenever it is applied for by the members of the petition association, the railway authorities will provide the actual weight specification of the empty wagons on which the coal is loaded. So you are okay with it?
Yes, it is there in my affidavit. So far, the RDS
No,
cases, my senior counsel has been.
Wait, what affidavit is it? Affidavit in opposition file. Where have you filed the affidavit?
Lordships, I am for the item number 10 and 11, Lordship.
No, WBC number 208
WPC number 4866 of 2012.
and 208.
And
208.
And Lordship in 208, Lordship.
5028.
208, what is this affidavit? Let us see what is the affidavit. We're going to look at it.
Lordship in 208, Lordship of 2013, Railway has submitted the affidavit on 1/4/2013, Lordship. In that affidavit, Lordships, Lordship, page 2, Lordships, 1A, that before going to parawise reply, this deponent begs to state and submits that a brief on the design, air, weight, and gross axle load limit of wagon for fixation of permissible carrying capacity. And Lordships, in page 3, Lordships, that is regarding the permissible gross load limit of wagons, inclusive loading tolerance, Lordships. Here, Lordships, this permissible carrying capacity is also based on this design air weight. On one hand, the parties are available to this permissible carrying capacity, which based on this designed air weight, not on the stencil tier. On contrary, they are complaining in the declaration of this actual design air weight.
Yes, what is this stairway business?
Lordship, subsequently, Lordships, I have filed one affidavit on 16/8/2013, Lordships, in WPC 4866 of 2012, Lordship.
What is this?
Lordship, on this additional affidavit, this paragraph 3, 4, 5, and 6 are relevant, Lordships.
You have filed an affidavit.
Lordships. Additional affidavit,
In which case?
Lordship 4866 of 2012, Lord. Additional affidavit, Lordship,
When did you file?
on 16/8/2013.
Additional affidavit,
Lordship,
23/8/2013. Yes. Tell me.
Lordship, this paragraph 3, 4, 5, and 6 are relevant, Lordships.
Now, what is this stairway business? Yes, Mr. Sharma.
Lordships,
What is this stairway? Empty wagons, I understand. Each wagon of a railway has a particular weight. And this is also reflected in the railway receipt. How much is the weight of the wagon or the measurements which have been done under 73? It has been shown that the weight of the wagon and the actual weight. That I understand. But what is this stair weight? Mr.
not
Counsel,
calculating.
you have filed the petition. Show me what is wrong with that order.
There with the vehicles. There you can check it. I can open.
Here
What is stair weight?
stairway means your lordship, if you lordship go to the my affidavit, stairway means your lordship empty. That have been designed by the specifically by the railway of the wagon. And that wagon, which earlier it has been mentioned as a your lordship as a stencil wagon. It can be marked. But here in this stairway means you're specifically by the engineering department where the wagon have been produced or built up as part of the circle of the route, railway track route, your lordship. It may be defined from northeastern railway to the central zone or western zone. That have been certified by the engineering department of engineers, whereby the routes have been, according to the routes, that weight have been done. And that their weight is a specification. As
Where can I find in your affidavit? 50?
I is your lordship 5028.
Let us see the impugn circular. What does it mention? Let us see what does it say. It's difficult to understand what do you mean by clear weight.
In
You are
my-
challenging which one? Ah, yeah. In terms of the board's letter dated so-and-so, permissible carrying capacity of different weights have been revised. These standard PCC of wagons are based on design care of the wagon and permissible axle. What is TARE? T-A-R-E?
Empty,
empty.
empty.
Design tear of the wagon. Then how do you say that what happened? The standardized PCC of the PCC is
Permissible carrying capacity.
permission of the wagons are based on design tear of the wagons and permissible axle load limit. Therefore, it has been decided that the design tear of the wagon should be taken as the benchmark for reckoning of overloading in any wagon. However, in those cases where tear weightment of empty wagons has been permitted, the existing procedure for calculating permissible carrying capacity of the wagon will continue to change as the details of the tear weight of different stock lying on and supplied by so this is the weight. So this weight, how are you getting the gross weight?
Gross weight,
Means or you are getting the
permissible weight.
permissible weight on the basis of subtracting the tear weight
Tear weight
from the gross weight. So what is wrong with it?
Lordship, because of this notification, Lordship, with the passage of time, Lordship, patching of iron rods, damage, etc. Lordship, because we are penalized for the overloading weight, Lordship.
How?
Lordship,
Now, how does it make a difference? Earlier, what was the system?
Lordship, they have fixed one design tear weight, Lordship. Imagine it tear weight, Lordship.
This they are saying on the basis of some engineering people doing it.
Yes, Lordship.
It was on standard parameters.
Lordship, this notification violation was section 34 standard of weight and measurement act, Lordship. Lordship.
You are saying as per it has to be done under section 34.
34. Standard weight and measurement act 97.
Let us see standards of weights and measures. Earlier, what was it?
Earlier, Lordship.
It was the empty wagon.
Time of loading, Lordship.
Huh?
At the time of loading, Lordship, the tear weight has been fixed, Lordship.
Now it is fixed prior to that.
Prior.
How is the tear weight fixed at the time of loading earlier, or which is presently going on? Is it put out there in the weighing machine?
Lordship, if Lordship come to my petition, Lordship, page 23, Lordship, we have annex one.
Which
Railway-
petition?
We
We are into 50228.
208.
Your affidavit,
Petition, Lordship. The petition, page 23 of my petition.
23 of your petition.
With annex one receipt, Lordship.
Yes.
Right hand side, Lordship, second column, Lordship, right hand side, Lordship. Second weight, Lordship. This was tear weight, Lordship.
Which one? First weight is inclusive.
First weight is Lordship as a whole, inclusive.
That is the
Second,
gross.
Lordship.
Then second is
weight
the tear weight.
weight of the empty wagon.
Yes.
Yes. And the last one is our
Now they have done what they are doing it on the basis of some specifications where they have already fixed the weight of the vehicle of the year have already taken note of that these boxes, like for example, you see wagons have particular names.
Types of wagons are there.
If Lordship come to page 23, third line, Lordship. Third line. This one, this show the difference, Lordship.
What is the third line?
Third line, Lordship, second weight, Lordship, tear weight. First one is 24.55, second one is 27.04, and the third one is 27.40, Lordship. These empty wagons are different from each other, Lordship. These empty wagons are different from this, Lordship.
So you are saying that these empty wagons each has a different weight.
Different weight. Okay.
And as such, it has to be done at the time when you are weighing.
And passage of time, Lordship, some fixes, some damage also, some iron plates also fix, Lordship.
Mhm. No, I get your point. So your thing is, all wagons doesn't have the same weight. So 1 ton here and there will be but I think you have a plus minus something.
Yes, two ton permissible. Lord.
Huh?
2 tons permissible.
Plus minus.
Lordship.
2 tons or no? Not 2 tons. I think this is given out in the
Not-
Railways Act.
Yeah, sir.
Some plus minus is permissible. Somewhere. Maximum wagons and trucks. Somewhere plus minus is permissible. 73. Where a person loads a wagon beyond its permissible limit as exhibited under subsection 2 or section of 72. The gross weight of every wagon on the axis when the Iman is loaded to its maximum shall not exceed such limit as may be fixed by the central government for a class of wagon under the Iman. Subject to the limit fixed under the Iman, every railway wagon shall determine the normal
Lordships.
over a railway shall determine the and exhibit the normal carrying capacity of the wagon or train.
Lordships, WTC 4866 Lordships. 4866, page 17 Lordships. Paragraph 8 Lordships. Here it is, statement is there. Earlier, up to 2 tons of loading tolerance was
Page
page 17 Lordships.
of the
WPC 4866.
WBC or the affidavit.
WPC Lordships.
Page. Yes.
Page 17, paragraph 8 Lordships. Middle Lordships. Earlier, up to 2 tons of loading tolerance was prescribed by the authorities, which means that if the permissible gross load limit of wagon exceeds up to 2 tons, there will not be any penalty on that excess weight.
Now you don't have. What is your reply to paragraph 8?
Lordships, my reply to paragraph 8 that the statements made in paragraph 8 of the writ petition are not correct, hence denied. The deponent begs to state that and submit that there is no question of debarring the merchant from getting the benefit of loading tolerance, and they will continue to enjoy it as per extant rule. The new permissible gross load limit of wagon is also inclusive of loading tolerance, which is clearly mentioned in the Railway Board's letter dated 31/8/2012 to take care of the situation arising out of design tear weight. The permissible gross load limit of wagons has been enhanced from 89.28 tons to 89.60 tons.
Now, one thing, Mr. Sharma, let us understand another aspect. See, the railway receipt is per 65. And if it is loaded at the owner's rate, then it is the weight has to be taken as if the owner has taken the responsibility. Otherwise, the railway receipt, if it says that this is the weight, then it will be that will be the weight. Now, how do you take care of that if the wagon is not weighed and there is a difference in the weighment of the wagons? How can the petitioner's rights be protected? Have you stated in your affidavit that be what may be, the weight which have been given in that circular is the exact weight of the wagons in question. Because they don't then have an opportunity later on. Do they have an opportunity later on to question? No. Because if they go for another way, because you can't take out the materials and weigh. These are all iron or just, for example, fly ash and everything which are there. These are all has to be weighed on the basis of the weighing scales which are there. Earlier, it used to be somewhere in nearby West Bengal and all. Nowadays, we have it in Assam, I suppose. Yes, you have it now. Now, there is a right of reweighment to the consignee and endorsee. Now, if the right is there of a consignee and of the endorsee, they are to accept the weight of that to be this, as per your circular. Is it your specific stand that the weight which have been mentioned in the circular, there is no difference out there? They're only worried that if it is not done so,
It is specific at your lordship. You can start with lordship. There is a specification, my lordship. There is a specification of the tier weights.
yes, I've seen it.
This one is there in my affidavit also.
No, I've seen it. It is there.
Yes, it is there. And so far, our party, his party is concerned, covered BSNA, BSNS 24.63. That is his have to again.
Now, where is the document, please?
Page 15 year old.
No, page 27 of this writ petition, whoever it is, 208.
Yes, Lord.
This is the weight specification of these wagons.
Lord.
So he said, his submission is, although these are being mentioned like this,
Lord.
but each wagon does not weigh exactly this. It may go this way or that way. A 2-ton difference here and there will make a hell of a difference. How do you take care of that? That is his submission, isn't it, Mr. Counsel? Nothing more than that.
Lordship, every individual wagon, it is not possible. So every tier weight of the wagon, it is not possible. Because there is en route, there is a wagon specification of their tier weight, and accordingly it has been built up. Now, in this case, your lordship, in my case also, he categorically cancel, challenge the quota weighment piece that has been defective. So for the quota weighment piece defective, there is no any mention as per the standardization. There is one rule as per standardization. We have formulated the wagon, and accordingly, your lordship, the railway circular which have been mentioned, although there is a little bit of contradiction in the railway receipt, which lordship has pointed out. But overall, your lordship, the en route of the rail which have been taken out in a rolling stock, that have been done as per the standardization. Earlier, it was done in a stencil wagon. It is marked up to this mark, you have to wait, and after, if it is overloaded, it will be punitive charges. Now, this is not done. It has been done by the computerized, while the weightman cross over it, automatically the weightman comes out, and the results come out. Now, here in this case,
this was there when I was also practicing. Yes. That I know. That is how, at that point of time, all these fly ash and all these things, when they used to come from a particular area, they used to be weighed en route.
on
One is there out there when it is loaded. They make a weighment, but this is on the basis of a declaration. On the basis of these number of bags we have put, and they take it that these bags contain this much, or cement. They bag. But when it comes en route, during this period, they make a weighment. And then they come up with that thing, and on the basis of that, they ask them that you are to pay. Now, they have a right out there, the consignee or the endorsee has a right to ask for reweighment. which they can do so. That till there I understand. But the only question out here is, these are various wagons where you have fixed the tear weight. Means this is the exact weight of this vehicle. Yes, rightly, it's your policy to do so, you can. But is it your stand that there is no way to, there might be this way, that way, there will be around 10, 15 kgs or 20 kgs, maybe a difference, which is hardly matters, or even a ton difference. This may happen because it can't be on the exact specification and nothing is done. But are you saying that it can't go beyond the tolerance limit? The difference, because they have to now accept, once this is being minus, here they will only minus 22.48. Just for example, at page 27, if it is a consignment in respect to an open wagon or BOXN, the total tear weight is 22.48. So this 22.48 will be the debt. So any weight beyond the permissible limits will be from the gross weight minus this 22.48. So the question of weighing the wagon doesn't arise any further. Earlier, the wagons, outside the wagon, there was a mention that what is the weight of the wagon. Isn't it?
Not.
Now, you don't need to mention it. You have already fixed.
Standardized fixed.
But do you weigh the wagon prior to that? I don't think you weigh the wagon prior to that.
Lordship, in our railway, we are doing the business. There's a time factor is there. Cost factor is there. Now his part here, there's a difference between the coal and the plastics. Iron rusting will be there in the, then definitely it will be decreases. And so far as some products are there, it's become expanded, it become increases. Now what will be that standard? If there is a benchmark of the two weight, either it will be excessive or it will be underweight. There is a one point. But so far his part is concerned, if you go to the coal, assuming you'll also have percolation of water in there while doing the moving the train, then it may be expanded. Then
or the weight may go up.
It may go up. What the railway department says, there is a benchmark so that there is a, what my senior counsel has said about the 2 ton plus minus. It can be adjusted. But if you, Lordship, permit me to, first of all, to give a satisfaction before this honorable court, you give me the first basement to whether wagon that which have been, I input search, whether I have been weighted or not. That cannot I give them.
Because normally, as I know, the wagons are normally, prior to its lifting, the wagons are not weighed. It is based upon the wagon, what is mentioned out there in the wagon, normally. And thereupon, when it comes out here, en route, it has been done on the basis of that. So their railway receipt, which is being given out there, is given at the owner's risk.
Owner's. He give the undertaken, your Lordship. While giving the railway receipt, he give the undertaken that this much is the wagon and this is the weight. If anything excess or if anything diminished, small, then he will be charged according to the expert payment. Now, here in this case, your Lordship, engineering department has a specification of the wagons.
So these are new wagons.
Every wagon, sir. It has been there. I have been mentioned all the wagons, designs of.
No, that I've seen it.
Yes.
So these are new wagons or old wagons?
New wagons, your Lordship. These are the new wagons.
So that is why it has been mentioned, something has been mentioned here.
Yeah,
The last paragraph. Therefore, it has been decided that the design fair weight of wagons should not be taken as a benchmark for reforming of overloading in any wagon. However, in those cases where tear weightment of empty wagons have been permitted, existing procedure for calculating permissible carrying capacity of the wagon will continue unchanged as issued by board circular. Now, what has happened here? There are two things. Permissible carrying capacity of different loads have been revised. These standardized PCC of wagons are based on design tear of the wagon and permissible axle load limit. So this is being done. Therefore, it has been decided that the design tear of the wagon should not be taken as the benchmark for reckoning of evaluating of any wagon. However, in those cases where tear weightment of empty wagons have been permitted, the existing procedure of calculating shall be done.
On the basis of railway risk.
Now, the interim order is in terms with the second portion. Which is what is the interim order? Look here, you see. In the interim, it is applied for that by the petitioner. If applied for, the railway will provide the actual weight specification of the empty on which the coal is loaded.
This is coal, Your Lordship. Mine is plastic. There's a differences between the cross. In my affidavit, I categorically mentioned about the differences. It has been mentioned. If you Lordship permit me to go to the paragraph 9.
Your case is which one?
5028, 2013. Your Lordship.
Here it has been given.
He mentioned about the coal.
Having regard, it is provided internet will provide the actual weighment specification of the empty wagon in which coal is loaded.
Coal.
So this interim order is not have no relevance.
No, the coal.
Mr. Counsel, who is appearing for 5028? Why did you get a coal order in respect to plastic?
By virtue of this coal order, I want to club here and take a escape. That is a hidden agenda.
Huh? Think about, I'm coming in 5 minutes. Huh? Now, madam, tell me, have you been affected by the impugned circular?
Lordship, in the order dated 3/9/2013, instead of the word coal, the word booth shall be substituted, my lord.
No, I'm asking you.
Lordship,
Have you been affected by this circular?
yes, Lordship.
How? There must be somewhere something must have happened.
Lordship,
Why have you challenged this?
Lordship, I have no any brief. I am not in this case, Lordship. Lordship, very shortly. maybe shortly give-
Then let him there. Yes, tell me, have you been affected by this circular? You are there in the other two?
Only one.
Which one?
208.
Huh?
208.
Okay. Now, have you been affected by this circular?
Affected Lordship, because of
Or is it on an apprehension you have done this?
Lordship apprehension.
Huh?
Apprehension.
What is this apprehension business?
Lordship, Lordship. This entire notification.
All over India, the same thing is going on. Nothing has happened. You are doing on the basis of a apprehension. There's nothing out there to show that you have faced any difficulty in view of that circular.
Because of this notification against
Somebody has filed a writ petition, got an interim order, so another you want to get another one.
If Lordship have the standard of weight and measurement at Lordship, if Lordship come to page, section 34.
Standard to be. Yes, page section 34.
Lordship, railway cannot fix any design weight, Lordship.
any custom, uses, practice, or method of whatever nature which permits a person to demand, receive, or cause to be demanded or receive any quantity of article, thing, or service to which the part apply in excess of or less than the quantity specified by the weight, measure, or number in the contract or agreement in relation to the said article, things shall be. So how is 34 involved? Yes, how is section 34 involved?
But they have fixed imaginary weight also. They have fixed imaginary weight also.
No, that's not imaginary. That has been done by a technical team.
In the notification, not mentioned about the
They have mentioned out there in the affidavit. Is it required to be mentioned in the notification to that effect? They have stated that it has been done by the technical committee or whatever may be. I only see the affidavit in opposition filed by respondent number 5.
Lordship. And also this lordship, this communication between the department not lordships. The letter is written by Joint Director Traffic Commercial to the General Manager, All Indian Railways Lordship. It is the internal communication. Hmm. 208. আপনার
Now the permissible is 89.6.
Lordships. Earlier it was 89.28.
28. So the tolerance limit is 1 ton.
And
Whose affidavit it is? 208.
208 Lordship.
Yours?
Yes, Lordship.
Kindly come to page 15.
Lordships, 15 lordships.
Eh? Council, why have you enclosed these documents? The Railway Board Circular dated 16/7/2013. The affidavit in reply. Yes, why have you enclosed this? The councils, give your names. Repetitions, you get the main order, all are dismissed. Pass the order.
Well,
Lordship, in this case, Lordship, my
Yeah, why do you- Yes, what is your case?
my son was arrested in a case under section 376 420 IPC.
Judicial inquiry by an impartial inquiry into the entire case so that actual truth will be unauthored and responsibility could be fixed on the person for whose negligence the petitioner's son died premature without treatment. Yes, madam, what has happened here?
Paragraph 19 of the affidavit is our reply, my lord.
Affidavit in reply, para 19.
But unfortunately, that inquiry report has not been annexed, my lord. One magistrate inquiry was done. my lord.
Para 19. Para 19? Yeah,
Para
that's
19.
so and so.
20.
Hirotsuka prisoners, namely upon so and so. Yes.
But in the affidavit, my lord, inquiry report has not been
What did the
annexed.
postmortem say?
Please,
Cause of snow resulting from coronary and probably due to underlying cardiac disease.
in our opinion, the cause of death is due to syncope resulting from coronary artery insufficiency, probably due to
Insufficiency, probably due to
cardiomyopathy.
underlying cardio. Then
And my lord, may kindly see, my lord, just above, my lord, above these findings, my lord,
Hmm.
more detailed description of injury or disease.
Hmm.
My lord, here written, my lord, all the changes are antemortem in the nature and the post-mortem examination done within 24 to 36 hours of incident. The finding of the cardiomyopathy along with the coronary artery rupture can lead to death of a person. However, to rule out any poisoning cause following, viscera are sent to forensic
Rule out
examination.
Where is it? In the type copy, it is not there. The
My lord,
postmortem.
my lord, 54 of their affidavit.
No, here there's a postmortem. I'm looking into it.
I am also referring this postmortem report.
Yeah, postmortem is where?
My lord,
Page 12, Annex 6, page 27. Opinion, all the changes are antemortem in nature and postmortem examination done within so and so. The finding of cardiomyopathy along with coronary artery rupture can lead to death of the person. However, to rule out poisoning cause, the following so and so are sent for forensic. Whole stomach and its content with the part of the liver, right kidney. Then what happened?
my lord, but my lord, they have not annexed, my lord, any, my lord, report, my lord, regarding.
Yes, yes, madam, have you done anything on that?
My lord, that annexure is the inquiry report, magistrate inquiry, but inadvertently, the only forwarding letter has been annexed, but report is part of inspection, my lord. That has.
My lord, my stand is, my lord, it is very much, my lord, he is behind the bar, my lord, judicial custody. So, my lord, it is very difficult for me to prove the, my lord, allegation and all this, my lord. However, the petitioner is, my lord, so, my lord, it may be a case of, my lord, poisoning also.
No. What has happened to that? Kindly come to the post-mortem report.
54 pages of their affidavit.
Huh?
Page 54 of their affidavit, that is the original one.
Page 54. Page 54. Yes. No, that is what I'm saying, that the finding, however, to rule out any poisonous cause following vicious and send it for forensic examination, container 1 and container 2.
Yes.
What happened to that?
My lord, report, the last paragraph.
No, report has to be given by the forensic.
Yes, my lord, but that was till the filing of this affidavit, probably that report was not.
Where is the forensic report?
It is not there, ma'am. Kindly peruse that,
Parawise complaint, forensic report, let us see the forensic.
last paragraph inquiry report, my lord, it is mentioned.
Stomach, medical of Philosophia, about University, according to railway applicant. Pillow, stool, weight, cold fever, nail injury. When did the accident happen, the incident happen?
My lord, 31st July 2012 at 12:35, my lord, as per their
I was called to examine.
12:35
so-and-so
AM
with
during
that number at the time of the examination, I found him in unconscious in a bed. So I on the heart sound on the will beside there. Dead. Medical report of so-and-so. Chief Judicial. No, madam. What about the forensic?
That is
Very-
not included in the.
Huh?
That is not included in
It
affidavit.
is an whole matter and you don't have the forensic till now. There's something then, something must be very seriously wrong.
My lord, I.
When he's alleging that there is some poisonous element involved out there, how come it is not there of a thing of a matter pending from 2012?
Let the matter be.
I think it's a fit case for giving it to the CBI. The police have gone astray.
postmortem was conducted.
Or is it because he is an UTP, so nothing is there? He doesn't have human, dead person, no human rights, nothing, or a UTP has no human rights. Why is this report not given when it was sent to the forensic?
Let me have it on record, my lord.
And bring that, not only that report, what about the forensic? Has the forensic
Yes, my lord.
given any report in terms of the postmortem? We'll have it when?
Next Tuesday or Wednesday. my lord.
Thank you. List the matter on 14th of September 2023. On which date? Miss M. Borman,
Right.
the Learned Counsel additional,
Junior government.
junior government advocate, additional or junior government, the junior government advocate shall apprise this court and bring on record the inquiry report so given by the executive magistrate, as well as to whether there was any report given by the forensic science. The report given pursuant to a forensic examination, which have been mentioned in the postmortem report dated 31st of July 2012.
Obliged.
Deeply obliged.
Lordship, may I pay for 1 day accommodation? Lord?
Why?
I'm not feeling well, Lord. That is, I have gone through the case. It's a case, Lordship, whereby we have challenged the order of the Human Rights Commission, Lordship, whereby and compensation of the rupees 3 lakhs of rupees 3 lakhs was given to the petitioner.
You got to stay?
No, Lordship, no stay.
You paid the 3 lakhs.
Lordship, that I have no knowledge, but after going to, we have challenged that order.
You paid the 3 lakhs.
That instruction I do not have, but we have challenged that order, Lordship, and most probably I will be able to satisfy
Government
your Lordship that.
as many as 40 days in issuing the final release order. This is for what?
Lordship, he was a life imprisonment, Lordship, life.
Illegal detention.
No. Illegal detention, no, Lordship. The remission part, Lordship. After 20 years, Lordship, and then it was calculated and the matter was referred to the government, appropriate government, and appropriate government, while sending back the, giving the approval, from the date of just completion of 20 years, and grant him the relief, that there is a gap of 1 month, Lordship. Because of that 1 month, the Human Rights Commission held it to be illegal detention. Accordingly, that compensation was given. The purely law point is involved, Lordship. I'm just praying for 1 day accommodation, Lordship. I'm not. Most probably, I will be able to satisfy your Lordship. That's because it's a life convict, means life imprisonment.
Why were you illegal? Why you was illegally detained?
Not illegally detained, Lordship, as because that life imprisonment is still life. So, taking into consideration of his the character and other relevant factors, it was sent to the government, and it is the prerogative of the government to accept that or reject it. And after verifying all those documents, Lordship, it was found that yes, it's correct. So accordingly, that relief was granted to him.
Release was granted on
If
28
your Lordship
2012.
comes to page 18, annexure 2, everything will be clear. That-
Government order for release of the said convict was received on so and so office holiday.
That is dated 31st of July 2012. Has your Lordship got it?
Office holiday. And
Yes.
file process. Inspector,
it is-
prisons approved.
He cannot claim it as a matter of right, Lordship.
For final release of the convict was submitted. Government also. Government order for release of the state convict was received by the DA. Office of IGP. The order was received on 23/3/2012.
Yes.
Then the
Then
holiday.
24th is a holiday, 25th Sunday, 26th file processed by the Office of the Inspector General of Prison approved it. Then 27 WT message sent, on 28 he was released. So from the document, Lordship, next page, annexure 3, page 20, down below, as your Lordship got it, remission to be earned up to.
These are the mentioned like convict and completed years of life. So this release was only given on 23rd of March 2022, 2012. And thereafter he has been released on 28th. And what does
The Human Rights Commission has wrongly calculated it, that your lordship will get it annexed 3 page 20. Has your lordship got
page 20?
page 20 annexed 3?
Ah.
Thus, total sentence period down below, remission to be earned up to 28/2/2012 to 1/2025. So they have taken this 28/2/2012 as the date.
So your case is till the governor passes the order, the question
Yes,
doesn't arise.
that is the law, lordship.
Then why you are taking time?
No, lordship, I am not feeling well. Most probably my sugar shoots up or down, something like
Okay.
that. That is why.
Chalo.
Otherwise, I would not have, lordship. I prepared the case also.
Okay. Then it's okay. We'll have it some other day then.
Any other day, lordship. Tomorrow also, lordship, I think I will be able to.
Yes, what do you have to say?
My
You
lord,
take your seat. Let him say, I have understood the point. Yes.
my lord, what happened?
You see, the remission order was put prior to the governor's order. He be released.
This Honorable Human Rights Commission has.
No, forget about the Human Rights Commission, what they say.
that is-
I'm only asking you a simple question.
Yes, yes.
Can a convict who has been sentenced to life imprisonment be released prior to the order of the governor?
Government order was, what happened, my proposal was sent from the district jail. This is the order of the 32, page 30.
Mr. Counsel, my question is very simple. Can a life convict be released without the order of the governor?
That is not correct. But what happened, my lord, there has
No,
been
no.
inordinate delay. They have-
Correct or not correct is
Yeah,
different.
yeah,
I'm
yeah.
only asking you a simple question. Can a life convict be released without the order of the governor?
The government's order is required.
Required. So the order was passed on 22nd of March.
Order was passed because this process was, it was due process. Process was continuing because there has been delay of around 40 days in the government side. So for that reason, he is unnecessarily, the calculation was there on 28/2/12. He was to be released. This was the proposal from the superintendent district jail. So after this clear proposal that he has to be released on 28/2/12 after calculation of everything.
Now, are you saying that you have an enforceable right to be released on the basis of that proposal?
That proposal has been prepared by the department itself.
Huh?
That proposal has been prepared by the jail department itself. For that reason, we are insisting, my lord, otherwise we had nothing to say. Because if it was government was saying that yes, his release will be also said, there was no such proposal from the superintendent district jail. So we had nothing to say. Because the proposal was that he has to be released on 28/2/12. But after this, there has been delay. They are delaying in their own process. They are negligently keeping the file pending.
Okay, tomorrow at 2 o'clock.
Lordship.
Is the matter tomorrow at 2 o'clock for final. You have to show me that you have an enforceable right to get an order from the human rights. You have a right on the basis of the proposal to be delayed. And there, because of that, a delay has occasioned.
Government has not considered that the delay should be only this because they are not overriding these other provisions. Because
No, your case is that it comes within the ambit of that there has been a delay in processing the papers for the purpose of order being passed.
Yes, ma'am. That is.
Otherwise, it ought to have been passed on 28/2/2012
Yeah,
or
he-
13, but it was passed on 22/3/2022.
Yes, yes, ma'am.
There has been this delay, which has led to for which you are seeking a compensation.
Yeah.
That's your case.
Yes, madam.
So whether this delay was in such a manner that compensation can be imposed on the basis of that. Because there has to be, you see, you have to have a right on the basis of that communication or that proposal that it has to be acted very fast. Like in the case of preventive detention. It is the mandate of law that it has to be done within a particular period. If you don't do it, will amount to illegal detention. That is the law mandate as per law. But here is the case you have in a life convict. Life, as per the Supreme Court, is life. But you can be given a remission out there by the government. Now, the papers of remission was delayed by 40 days, for which the Assam Human Rights Commission has imposed upon them the period. That's the case, long and short. 2 o'clock. 14. Tomorrow, 2 o'clock, I'll hear if you have changed anything. Yes.
Map is not.
What are you doing with this such an old matter?
Minor.
Ah,
Minor
don't
matter.
keep hearing about it. Yes, tell me.
Mission is the social status certificate to the respondent number 7 minor.
What is your prayer to quash
Hello.
the impugn order remand being illegally passed by respondent with malafide intention to confiscate and impound the impugned caste certificate of the private responding being obtained fraudulently by impersonation? Who is this private respondent? Let us see. Sanjit Talukdar.
Minor. Minor, petitioner minor.
Nomination of the as a chairman of so and so by the impugned notification as devoid. It's all on the hinges on the caste certificate.
Minor.
And what is this order you have challenged?
Minor, that is
14,
annexure
8,
14 minor.
2013.
Order dated 14 August 2013 minor, passed by the third level committee minor. Holding that that hard to
Complaint
Caste
received
status
from
minor.
Dr. Das, president of so and so for waiver of the caste status of Prasenjit, chairman of so and so. And the Prasenjit belongs to HC committee and we are talking decision on problem. Part of her is done for the right. Then
Minor. Minor in the impure order minor, they have been considered minor, which is not what to be considered minor. Because minor in the impure order minor, approximate that the minor respondent number 7 is not belong to minor scheduled caste community minor. So accordingly, minor, he has been minor nominated as a chairman of the minor Borpata district welfare board minor. Coming to the minor petitioner has understand of the secretary being the Borpata district association filed complaint before the authority, and that application has been treated as a minor complaint and has been SLC has been entered in the matter minor. So SLC minor when into the matter minor, there are two reports, one from minor SDO minor, one from DC minor. The DC report has been considered minor. Whereas the earlier minor SDO has filed a report minor on that basis minor, it is not found to be minor, it belongs to scheduled caste community minor.
what does the state level committee pass? Which order?
Minor, that annexure 14 minor,
Annexure?
base 53.
Annexure 14, I have read it.
Minor, that is past minor.
Yeah. This is by the government. This is not by the SLC.
Minor,
SLC. my lord.
Oh, chairman, SLC.
My lord. This is under silence matter.
Yes, well, so what is wrong with that order?
Wrong with them, my lord. In the scrutiny committee, my lord, we have filed objection, my lord.
Uh,
Those have been not taken into consideration, my lord.
What is
Which
this
are
objection you
forwarded
have?
to the, my lord, private respondent.
Are you saying that his grandfather was not a cooperative?
No, my lord. He is the first generation, my lord. From him, my lord, he is using the, my lord, the certificate. Earlier, my lord, he went to Kinder College admission also. No,
And what
my lord.
about his father?
Father, but they have not never used by that.
No, the father has filed an affidavit, something.
No, my.
It has been mentioned. Only see the paragraph, page 53, paragraph 4. You have not seen the impugn order?
My lord.
See the impugn order? Paragraph 4. Because this is a finding of fact. How does this court interfere? Unless you show some perversity.
But except that, my lord, one main question is this, my lord, the committee is should have been by 5, my lord. That is also under, my lord.
Huh?
The committee should have been by 5 members, my lord, as per the Supreme Court judgment, my lord.
Which committee?
That SLC, my lord.
Show me that.
My lord, here, first is the Marty Patel case, my lord, that's what the Marty Patel for 94, my lord. It is due by 3 member, my lord. Thereafter, my lord, here, I have been filed a modification that the 3 judges, the Supreme Court held that it should be by 5 committee. SLC because by 5.
SLC.
SLC.
How are you saying that it is not by 5?
No, my lord. Here is, my lord.
No, it is only the chairman who has signed this report.
My lord.
But are you alleging that it has to be 5?
My lord.
Where is it in your, let us see what do they say in the affidavit. Yes, Mr. Ahmed, when did you get your first caste certificate? At the age of 35?
It wasn't kindly say my affidavit.
That is what I am looking into.
Yes. It wasn't kindly say.
Because your affidavit was filed on 3rd of August 2015. There the age has been mentioned as 41 years. The caste certificate which we are referring to is of 2010.
Yes.
Meaning thereby around 5 years before, which will be, that means you got your first certificate at the age of 36.
Annexure 1 page 6.
Understood, but how are you saying that you got your first certificate in
Yes, my lord.
when you were 36 years old?
Because
You did not take any benefit when you were studying.
my lord, yes, yes. Because when I come to learn that my father, grandfather are
Oh, very interesting it becomes.
then my lord,
It is on the basis of some horoscope?
no, my lord.
Okay.
No, my lord. It is not there. But that certificate is issued after.
Now, how did you know that your
During the
father was from the scheduled caste?
Because all documents are there. I issued.
Show me that.
Yellow kindly see. Yellow kindly see first, page 8.
Yes. This is of something in 2008,
Right.
just 2 years before your caste certificate.
My lord. Then, my lord, and before that, my lord, you kindly see another page 10. Page 10, another certificate, my lord, rebook, my lord.
This is of 2009,
9.
1 year before.
Yes. Then,
Yes.
my lord, you kindly see the page 15.
Huh?
Page 15, my lord.
Yes.
So the land document. That page 16, my lord.
Huh?
Page 16.
Certified copy of our Jamabandi
Yes.
of 1923-24,
Yes, ma'am.
28th of copy pattern number so and so. Tag number 4. Whose name it is?
Yes, Cooperative. Again,
Huh?
the Cooperative.
Opinion, my lord, as per order.
Your grandfather's name is?
Yes, Koiboto.
Huh? Haro Koibotor.
Yes.
Okay, now tell me, what happened to this land?
The lands are there. There,
No. It must have now, after your grandfather, must have gone to your father
then father,
and to you.
then.
To you, obviously.
My lord.
What happened to this land? Or did Haro Koibotor sell of the land?
But,
Because
my
this is the document on which you are making the entire basis.
Yes.
Then what happened to this land?
land is there.
Where?
I have no claim.
No. That is the most important. If this is the document on which your entire thing, because the other documents was just 1 year before where you realized that your grandfather was a Koibotor.
But the loss of country before that I lost it. Phase 12 and answer 5. The loss of country. And the document.
Yes.
This is the inquiry report, my lord.
Hmm.
That inquiry report, with reference to the subject cited above, I have the honor to inform you that the allegations in respect of percentage collectors, chairman, has been inquired by SDO Borpeta. As per inquiry, it is found that percentage collector belongs to SC Koiboto community. Therefore, 87 page record are there. All the documents we placed before the inquiry.
Mr. Ahmed, you just tell me only one thing. What happened to this land?
At present, I cannot say, my lord.
Then, if your entire basis is this, only this document, whereby your grandfather is Haro Koibotor or Haro Mohan, alias Haro Mohan, and now your father happens to be a talukdar, and you happen to be a talukdar. So you draw your analogy from there. Is it anywhere mentioned that your father's name has been mentioned somewhere? That your father's father has been mentioned as Haro Koibotor anywhere?
Monday I will clear.
Huh?
Monday I will clear.
What is the Monday? This is the 2000.
I will bring it on Monday.
Yes, madam. You are the main person who have done all these things. And where is the WPT, Mr. Ardhor?
Before I enter into the merits.
I have read that particular report. The reports and all the documents which are there in the affidavit shows a conscience as a reason amongst him. Because he was 41 years when he filed the affidavit in 2015. He encloses a particular document of the year 2010, which is 5 years before, meaning whereby till 36 years, he did not have a caste certificate. Prior to that, 2008 and 9, there are certain verifications being conducted. On the basis of a land document of a particular dag, wherein 3 persons' names have been shown, including the name of his alleged grandfather, Haro Koibotor. Because there is nothing which shows otherwise a link to that effect.
The record is also here. However, before entering into the merits, if I may be permitted to draw your lordship's attention to another aspect of the matter.
You are challenging the locus?
No, my lord. What is the right that is affected that is not seen in the petition?
Oh, definitely. Why not? If he is not belonging from the SC, he doesn't have a right to contest the election.
So he became the chairman of the Scheduled Caste Development Board of Borpeta. He has even issuing caste certificate. He has not-
This is the Borpeta Scheduled Caste organization, na?
Well, on facts, the record reveals, well, there's a record, the inquiry report, the local verification. Well, that is dated 5/8/2013.
Yes.
Well, here it says that the local revenue authority claims that Haramohan Das, late Haramohan Das, grandfather of Prosenjit Talukdar, was a person belonging to the scheduled caste community, and their forefathers had the name Koibotor against their names. Further, also, they clarified the matter of issuing scheduled caste certificate in favor of Prosenjit Talukdar.
Where is the records for that?
Here, madam.
the records for forming that opinion. Because that is a very relevant thing. Because one fine morning only you realize at the age of 36 or 34, exactly. Why at the age of 34? When the constitution came in the year 1950, granting liberty under 15.4 and 16.4.
23-24, my lord.
Eh?
Land document.
Yeah, that is what 23, 24. And whether that land, in fact, was sold by his grandfather, whether that land has then devolved upon his father, whether those things have been taken note of.
That does not figure here.
Absolutely. That is why otherwise this court normally does not interfere with the finding of fact. But this is something very perverse. Because the entire, only one document plays the entire thing. The document pertains to this land document. What has happened to this land?
This is the report of the state level committee, madam.
State level committee has given that report which has been put to challenge 14.8.
On that basis, my lord, on that basis, the 14/8/2013 came to be
There is
passed.
another one.
Yes, madam. This
What
is
does it
the-
say?
It says clarified, the land revenue officials also clarified the matter of issuing scheduled caste certificate in favor of this Prosenjit Talukdar was verified by the revenue authority on the basis of available land records, which indicates that the forefathers of Prosenjit Talukdar belong to the
Now,
scheduled caste.
how did they verify that?
The lineal, my lord.
Huh?
There's
How
a
did
legal
they
head of.
verify that land records? Unless they say that this particular land have devolved upon the father.
Well, I'll ask for this. Lordship grants me a week's time.
List the matter again on 19th of September 2023. So Miss S. Sharma, the Learned Council Government Advocate, shall apprise this court as to how the authorities concerned had linked the land revenue documents of Harakoboitor with the petitioner's father as well as the petitioner.
All right.
Where is Mr. Mahmood? Yes, Mr. Mahmood. What case you have?
Timing item
You
7.
have a problem with respond number 4, 5, 6, and 7.
No, they are, no doubt they are private persons. Private persons,
Yes,
But,
go get an injunction.
my lord, kindly consider this. First thing is this Chilarai, Vishwa Mahavir Chilarai Bhavan has been allotted certain plot of land, nearly 15 acres of land. There were a large number of communications between the All Assam Coast Rajbanshi community, Sonmilani, and the government of India, Archaeological Survey of India, government of Assam, etc. All were in my name, being the vice president and president of the and the member secretary of the construction committee. Now the work has been already started. Already a building has been constructed. In the second phase of construction, a pond was going to be constructed. At that time, the private respondents came. Our case, they demanded heavy money. I could not pay. Then they created obstruction. Then I'll file a case before the officer in charge of Bongaigaon police station. Not only filing case before the OC, it was also filed before the SP. But they did not take any appropriate action. For years, I am afraid that if I continue the construction, I may face consequences. Now, yes, Lordship is correct. There is the code. The first court would be the CJM court. And if CJM court passes order, which may be advanced against me, then I'll have. to
No, the
just-
CGM court will only, that FIR will ask if you have been able to make out some prima facie case, will direct the police to investigate. You want that investigation only. Why should this court pass an order in view of the various judgments of the Supreme Court? And it is absolutely a matter between you and them.
No, they
Why
are
should this
claiming,
court at all
my
interfere
lord,
and bring Mr. Henry
they are
and Mr.
claiming on
Bhattacharya
air
of the-
because government is saying the land has been handed over possession to the all Assam Conservatory Sovereignty. They are.
Mr. Mahmood, there is no denial to the fact that I am not even denying or saying that the land has not been allotted to you. But the land, just for example, you have a plot of land. You are the owner of the plot of land. If tomorrow he disturbs you, what are you going to do? File a writ? No. You have to get an injunction. This is between you and him. How do you involve him?
That is one aspect of the case. Another
There is
alternative
no
remedy.
aspect to the writ.
My lord, I have given this suggestion.
You again being an SP.
My lord,
SP or no SP, nothing doing. You file your 156(3), and if you want to file suits, not to disturb, get an injunction against him. This court won't pass an injunction, not for them not to disturb. Can this court pass an order? Not this court at all, maybe some other court. Not this.
Lordship is aware about the alternative remedy is not always a bar to provide relief by.
Absolutely, there is no bar. But it is
I
a
have
question of
also-
exercise of discretion. Why
Yes,
should
yes,
this court at all exercise a discretion out here when there are remedies which are there are already available? That very police station out there can be the CGM of that particular court can very well direct the police out there to make an investigation. That civil court can very well give an injunction against
Yes,
these private respondents. Then why should this court? It is absolutely a dispute between both of you. Has nothing to
No,
do with
no,
him.
dispute is for the sake of dispute. They have nothing. They have filed
Understood.
affidavit,
Let
I
us,
think they are
let us assume. Now, can this court today direct them? Then don't
No,
disturb
I
them.
am not, I am only saying that the SP or a law enforcement agency may be directed not to disturb. That is my prayer.
Now, are you saying the law enforcing agency is disturbing you?
No, they are not disturbed.
Who is disturbing you? He. Then. That is why you don't have a case.
I
of-
cannot fight with them.
Whom?
So I want help of law enforcement agency. I cannot fight with them.
You take it, the law enforcement agency will take care of it. These people will, you have to get it done through the
My lord,
CPM.
may I give some alternative there? That lordship may kindly, this is the chairman of the Constitution Committee. So lordship, if your lordship kindly give us liberty to file an application because that is that, in that view, case may be disposed of, not dismissed of.
Huh?
In that view, case may be disposed of. Our prayer is not to dismiss what may being a wrong message. That is my prayer.
I will close it on your withdrawal with a liberty to approach those authorities. What do you say?
For that, my lord, I have to give in instruction. But withdrawal, for withdrawal,
I can't dispose it of.
it is an order.
I will have to say that this court is not going inclined to entertain this petition in view of the provision, in view of the judgment of the Supreme Court in the case of Sakira Bas.
Judgment. I have also seen the alternative remedy is not a bar. That is also there. Judgment is in this way, that way, there are so many judgments.
Show me a judgment for
Yes,
that.
ma'am.
Let me also clarify that aspect.
Yes, I have given the satisfaction.
In respect to a police
Yes.
dispute,
That is 1999, 4 SCC, 450 Hindustan Petroleum Corporation Limited. Here, para 9, my lord.
this is pertaining to,
Alternative, it is pertaining to maintenance. Maintenance.
this is pertaining to the LPG.
Dolly Das, versus Dolly Das. It may be Hindustan Petroleum Corporation Limited. I am.
Wherein it has been mentioned that the fundamental rights have been affected out there, then obviously this will not lie, isn't it?
My lord,
That is the judgment.
right. It is as good as statutory right, because I have been handed over the position by the authority. That you take the position, I have taken position, I have constructed.
No, Mr. If you insist, I dismiss
No,
the petition.
my submission is this, my lord, for
Hmm.
withdrawal, my lord.
let it be fixed on
No,
any
no,
other
this
day.
is the case of
I will take
dismissal.
instruction. Because it is an organizational case, man.
The
organizational case.
instant writ petition
So
has,
if I withdraw,
listen, I'll pass the orders. Listen to what I am passing. The instant writ petition has been filed by the petition. Seeking a direction upon the respondents and more particularly the private respondents. Not to thereby restraining, seeking a direction of restraint, direction to the private respondents to restrain them from disturbing in the ongoing construction of the Naranarayan Silarai Kolokshetra, as well as also the pond within the Kolokshetra area. It reveals from the perusal of the petition that there was an allotment of a plot of land for construction of Naranarayan Silarai Kolokshetra at Chaprakata Part 1 of a plot of land measuring 12 bighas, 2 katha, 15 lechas covered by dark number 153 situated at village Chaprakata Part 1 under Bongaigaon Revenue Circle in the district of Bongaigaon Sam. It is the case of the petitioner that a petitioner who is a class 1A category contractor was permitted, was issued a work order for construction of the work. However, the private respondents numbers 5 to 9, as claimed by the petitioner, illegally entered into the construction site on 8/11/2022 and asked the petitioner number 2 to stop the construction of the Kolokshetra work having no authority. Under such circumstances, the petitioner had lodged an FIR on 14/2/2023, requesting the police to investigate the matter and to take necessary action against the accused petitioner persons who are the private respondents. It is further mentioned in paragraph number 7 of the writ petition that there were repeated attempts between the petitioners with the private respondents to come to a mutual understanding. However, there was no progress. And as a result of which, the Caste Rajbangshi communities have been deprived of the valuable past history and culture. It therefore this court further takes note of the FIR filed on 14/2/2023 enclosed as Annexure 10, wherein there are allegations being made against the private respondents. I've heard the learned counsels for the parties and have perused the materials on record. The dispute in question is absolutely a private dispute between the petitioner as well as the respondent numbers 5 to 9. 5 to 9 or 10?
5 to 9.
5 to 9. Full stop. There is also no allegations made in the writ petition that the respondent police authorities have not taken any steps pursuant to the FIR. Under such circumstances, now, full stop. Taking into account the above, it is the opinion of this court that as the dispute raised in the instant writ petition is purely a private dispute between the petitioner as well as the respondent numbers 5 to 9, the question of exercising any jurisdiction under Article 2 to 6 of the Constitution is therefore not called for. The petitioner is always at liberty to take actions under the provisions of the Code of Criminal Procedure 1973. If the FIR filed has not been brought to a logical conclusion, or to take or initiate civil remedies as permissible under law. In that view of the matter, this court finding that the instant writ petition, in view of the above, this court is not inclined to entertain the instant writ petition. For which the writ petition stands closed. However, liberty, as mentioned herein above, would be available to the petitioners if otherwise permissible under law.
Much obliged.
By a ready order.
Eh?
By a ready order. All right, fellow.
I have to use the different words.
15 to 18.
All right.
Gita? Yes, Mr. Goenka, you have challenged.
Income tax matter.
What have you challenged?
I have challenged notice issued under section 148. The notice is read.
challenged the notice.
Annexure 8, page 119.
Recording the reasons for cancel, recall, receipt of order dated demand, recording the reasons for issuing the notice dated demand, notice under section. Notice under. Yes, you are referring to a 148.
148.
What is the page number?
My lord, 148 notice is at page number 119. Annexure 8.
Yes.
My lord, it says that assessment year is 2011-12, whereas I have reason to believe that your income chargeable to tax for the assessment year 11-12 has escaped assessment within the meaning of section 147 of the Income Tax Act 1961. I therefore propose to reassess the income for the said assessment year, and I hereby require you to deliver to me within 30 days from the service of this notice a return prescribed in form of your income for the said assessment year. Then, my lord, the last paragraph says, this notice is being issued after obtaining the necessary satisfaction of the Commissioner of Income Tax, the Central Board of Direct Taxation. Central Board of Direct Taxation.
Yes.
My lord, the Commissioner of Income Tax is not the prescribed authority to approve, to sanction the issue of notice under section 140. I will make my submission on this point, my lord. First, my lord, I will take your lordship.
Here it is only mentioned after obtaining the necessary satisfaction.
Yes. Now, he is not the appropriate authority whose satisfaction is required.
Okay.
It's only the Joint Commissioner of Income Tax whose satisfaction is required.
So the higher authority satisfaction is not relevant.
No, not relevant, my lord. Once the Act provides the satisfaction of a particular authority, it has to be the satisfaction of that particular authority only, my. There are a number of judgments on this point. I'll place, including our own High Court, my lord. I'll place.
So you
Then,
are
my lord.
challenging this on what ground?
My lord,
Why are you challenging this?
because then this notice is not valid.
No, yes, reason?
Reason is that it has not been issued after obtaining satisfaction of the appropriate authority.
That is one.
That
Then
is one. Second, my lord, I am coming to the reasons recorded. My lord, here, section 151, if I may place before your lord.
income tax concern.
Very well.
Yes.
Section 151, my lord. Sanction for issue of notice. Subsection 1, no notice shall be issued under section 148 by an assessing officer after expiry of a
No,
period
you are
of
reading section 151?
151(1).
151(1). No, here it starts with specified authority for sanction of sanction for the purpose of section 148 and 148A shall be the principal
My lord,
commission.
Which edition your lordship is having?
The 2021-22.
My lord, in 21 there was change, my lord. I am giving you.
So prior to that, what was it?
Prior-
No notice. Yes, I've seen it. No notice shall be issued under section 148 by an assessing officer after the expiry of 4 years.
Period of 4 years from the end of the relevant assessment year.
Yeah.
Unless the principal chief commissioner or the chief commissioner or principal commissioner or commissioner is satisfied
On reasons
on the
recorded.
reasons recorded by the assessing officer that it is a fit case for issue of such notice. Now, this is a case where the notice is required to be issued after 4 years from the end of the relevant assessment. After the expiry of a period of 4 years from the end of the relevant assessment.
No, here it says no notice shall be issued under a year by an assessing after the 4 years. There's a limitation is 4 years.
4 years. If we issued after 4 years, then the sanctioning authorities are the principal chief commissioner or principal commissioner or the commissioner. Their satisfaction is required. Is satisfied on the reasons recorded by the assessing officer.
So if it
a
is
fit
after the expiry, then the principal, okay, then
Then, my lord, in the case other than a case falling under subsection 1, that means where the notice is issued before the 4 years. no notice shall be issued under section 148 by an assessing officer who is below the rank of joint commissioner unless the joint commissioner is satisfied on the reasons recorded by such assessing officer that it is a fit case for the issue of such notice. Now, my lord, in all these cases, the notices have been issued before the end of 4 years from the end of the assessment.
Okay.
So, my lord, the appropriate authority whose satisfaction and sanction was required is the joint commissioner. And the definition of joint commissioner is given in the act itself, my lord.
Yes. Joint commissioner is given where?
I'm 228C, my lord. 228C. Section 2, subsection 28C.
Joint commissioner means a person appointed to be a joint commissioner of income tax or an additional commissioner of income tax under subsection 1 of section 117. Okay, then.
So, my lord, my submission is that the satisfaction and the sanction has to be from the joint commissioner.
Because it is prior to 4 years.
4 years. The chief commissioner and commissioners, they have also been defined in this section, my lord. Subsection 215A, subsection 216. Then, my lord, I will come to the next page, page 120. Where the regions are recorded, regions for issuing notice under section 140. The SAC sold shares within bracket penny stock is identified by SEBI and investigation wing Kolkata during the financial year 2010-11, details given here under. The date of transaction, script name is given, amount is given, and the broker code is etc. is mentioned. The next paragraph says, my lord, but as per the return file for the assessment year 11-12 relating to financial year 10-11, no income oblique loss in respect of sale of shares have been disclosed. On the basis of information received from the ITD penny stock, I have reason to believe that the income has escaped assessment. Consequently, the case for the assessment year 11-12 is reopened under section 148 by issuing notice under section 140. My lord will see the only allegation in the regions recorded is that as per return filed under for the assessment year 11-12 relating to financial year 10-11, no income oblique loss in respect of sale of shares has been disclosed. That is the only allegation.
Then,
my lord, the sale of these shares and the profit or loss derived from the transactions have been duly disclosed in the return of income filed by the writ petitioner. My lord will kindly kindly see page 96, my. It starts from page 94, annexure 5, my lord. This is scope, and 93 is the receipt of my return.
Yes.
94 is the computation of my total income, my lord.
Mm.
And my lord, kindly see page 95.
Mm.
Details of exempt income in the middle of the computation. Capital gains STT as per annexure 1013, 57,28,923. Now, these are the capital gain which I have disclosed. And the next page, page 96, my lord. This is my computation part. It gives statement of long-term capital gains, transaction tax, exempt income under section 1038. Full details of the shares, those have been sold. Sale price, purchase date, purchase cost, and the capital gains. This is fully disclosed in my return of income. Then my lord will kindly come at page 115.
Mr. Goenka,
Yes, my
if
lord.
I'm not wrong, here at page 120,
Yes, my lord.
there are 7 transactions.
Yes, my lord.
And at page 96,
Yes, my lord.
6 transactions. Why 1 transaction? In
My lord, what has happened? Here they have given transaction wise detail. Here we have given script wise details.
Mm.
And here page 120, your lordship will kindly find the total amount comes to only 37 lakhs.
Mm.
Whereas in fact it was 57 lakhs 28,920.
Capital gains.
Yes, ma'am. And what they have shown is the sales 3743. The sales which I have shown is 60 lakhs 41. So they have left out certain transactions.
So there was more disclosure.
Yes, more. Then my lord, kindly come to page 115. Page 115 is, my lord, the printout of income tax return. Hundred and 15 printout, my lord.
Just 1 minute. 15.
At the bottom of the page, my
Ah.
schedule E1, EI, my lord, exempt income, details of exempt income not to be included in the total income. Serial number 3, long-term capital gains from transactions on which security transaction tax is paid, 57 lakhs, 58,923. This is exactly the same amount which I have shown in my computation of income.
Yes.
Then, my lord,
Yes.
My lord, I'll draw your lordship's attention to order dated 14/9/2016.
Where? In this case?
14/9/2016 passed by Honorable Division Bench in this case.
Where? Here?
Here, my
9,
14/9/2016.
16.
16.
Yes. Oh, yeah. Why was it before the division bench?
It was earlier, maybe because of rules of
Tax,
business.
yeah,
The matter was before them. It was before Honorable Mr. Justice Hrishikesh Roy and Mr. Justice N. Chaudhary. I'll just read out this order. The petitioner is an assessee under the Income Tax Act, and he challenges the notice issued under Section 148 of the Income Tax Act 1961, where under the reassessment of income
Mr.
alleged.
Goenka, I've read it. So here it has been recorded that it has been done on an incorrect premises and all.
Incorrect.
So your question is twofold. One is 151 stipulates that if it is a case falling within
4 years.
within 2,
Yes.
151(2),
My lord.
then it has to be, the permission has to be, or satisfaction has to be of the Joint Commissioner.
Right.
Joint Commissioner has been defined in Section 228. The second is, when they issued the notice, they have given you the reasons, the basis of which it had the reasons to believe.
My lord.
It mentioned about various scripts out there which have not been disclosed. However, it would be apparent from the return which is being submitted by you, at more particularly at page 113 and all, to the effect that this was very much disclosed.
Yes.
So they did not have the reasons to believe.
Yes.
That's all.
Your lordship want, I can place judgment on 151(2).
Yes.
If your lordship so desire.
Yes, yes, you can give, but we will hear it on again on 12th. What do you say? I'm done with this because he has to be heard now.
My lord.
That's it.
If possible, my lord, it can be taken on 20.
No. I've already heard you. Matter is over. You are. Because I will only declare the case.
My lord, I will.
Your argument is over. Anything else? You can give the judgments. That's okay. But your argument is these twofold. You can give that judgment because the reasons have been already mentioned out there, which have been taken. Now he only has to show is as to whether they have actually taken into account those aspects of the life. Because that is, otherwise I would have not entered into. But if it is a case of perversity on the face of it, this court can definitely look into it. Because this comes within, and I've seen your reply. You have given a reply out here, wherein you have mentioned out there, more particularly at page 5th of July 2016, Annexure 129, where you have given a reply.
Yes, sir.
So that reply you have said that all these things have been, details have been given to them. So now I have to hear him only.
And my lord, in their counter affidavit, they have also admitted as to whatever we have stated about the share transaction is correct.
Then what remains?
I think there is no admission.
Oh, there is no admission.
There are 4 of the affidavit in opposition.
Yes, there is no admission. The same are matter of record, and as such, the answering deponent doesn't want to make further comments. The same.
In para 4, they say, my lord, that in response to the statements made in paragraph 2, 3, and 4 of the writ petition, the answering deponent does not want to make any comment. Their own is the same are matters of record, and as such, the answering deponent does not want to make any further comment. Now, this para 2, 3, and 4 of writ, Now, in, my lord, in para 4,
No, you see, I've seen your affidavit. What you have stated in your affidavit is this, that 148 reasons to believe has to be there. The sufficiency of the reasons may not be the question out there.
Yes.
But if your reasons which are based is already been shown or reflected in the records on the basis of the returns. Now, can you say now that we, for doing it, opening or reopening or reopening the assessment out here, we may give any reasons whatever we like. But later on, we will look into it further. Can you say that?
That cannot be. That cannot.
So you only have to show me the discrepancy if you have a case. The discrepancy between the returns so submitted
And
and the reasons to be. If there is a discrepancy, this court won't touch it.
Okay.
But if there is no discrepancy,
yes, okay, then we have to.
that's all.
With regard to issuance of notice, that also, one point has been raised, that the notice to the satisfaction of the commission was taken, although it should be from the joint commissioner. I'll certify lordship, I have obtained some instruction also to that effect.
That is another point which he has said, that if it is the case after 4 years, then the permission has to be taken or the satisfaction it has to be of the commissioner. But if it is before 4 years, then the permission has to be taken from the joint commissioner, the satisfaction.
Yeah.
He says when it is the satisfaction of the joint commissioner, then how can a commissioner's satisfaction do?
So that I'll satisfy.
Hmm?
On that point, I'll satisfy.
These are the two.
Yes, sir.
And Mr. Goenka is going to submit some judgments, give it to me and give it also to
yes, my lord.
the income tax department, which is otherwise very rich, but then also taking into account the
One,
the here is less available.
My lord,
The
there are three judgments.
logistics being lesser, copies may be given to him also.
fixing on 12th. No?
So he is referring to 3 judgments.
3 judgments. One is our own high court. Country roller.
One is of Bombay High Court.
One is Bombay High Court by Justice and the 2 D.Y. Chandru. One is Delhi High Court by Justice Ikri. And our own High Court, my lord, and 3 roller floor mills. I've given it for free kindly. Lordship may kindly see para 16 and onwards.
Okay. The learned counsel appearing on behalf of the petitioner have been hearing of the learned counsel for the petitioner is complete. Mr. Ezekiel appearing on behalf of the GST shall make necessary
Income tax.
submissions
Income
or income tax. Shall make his submissions on 12th of September to be taken. Which is the matter at the top of the list after the ladies still observed. After item number 12.